স্ক্যান করে subject to the convenience. So
What
here,
is
my lord,
urgency?
but the urgency is, my lord, the bank accounts of a political party all have been, my lord, freezed. This we came to know, my lord, from a press release day before yesterday.
No, already the matter is pending with you.
No, that is, my lord, against the state police,
Okay.
on which, my lord, there is an order yesterday. Some protection has been granted, my lord. Now, this is, my lord, as your lordship knows, my lord, under the PMLA, my lord, they require a predicate case. The predicate case is before the other court. Now, this after the predicate case, my lord, has been initiated, then, my lord, they initiate proceeding under the PMLA, and the same bank accounts, my lord, have been seized or rather freezed. If your lordship kindly keeps it, my lord, sometimes in the month. Yes.
Monday actually.
Monday, my lord, towards sometimes.
Monday within 10 minutes.
Well,
Issue notice.
well, I'm so grateful. Attention to the.
My lord.
Yes.
Lordship said today morning I have come. Lease matter. My lord, yes, urgency too much urgency because.
What is the urgency?
My lord, 4 years girl, she is not admission in school.
Which school?
St. Xavier's.
Which class?
Class KG.
KG. Your parents are not having the your parents' name has been deleted.
Yes, my lord.
Okay. Oh, Wednesday within 10 minutes.
My lord, may I be allowed to mention a matter, my lord? My
What
lord,
See,
may I be allowed to mention a matter, my lord? My lord, this is also SIO matter.
today is not the mentioning day. If
My lord, kindly hears me out for 1 minute, my lord. My lord, it was made returnable on 7th of July, my lord. My lord, there is urgency. The DIB officials are harassing me every day, my lord. I'm a 57, 58 years old lady, my lord.
Ah.
My lord, without a reasoned order, my name has been deleted from the e-roll, my lord.
deleted from?
The e-roll, my lord.
Ah.
My lord,
So
kindly.
So what is the urgency in that?
My lord, the DIB officials are harassing me, calling me to their office. No order has been issued, my lord. Only the name has been deleted. My lord, kindly includes this matter. My lord, the returnable date was 7th of July, my lord.
7th of July, you filed you mentioned the returnable date. Earlier the
My lord,
matter.
I have tried to mention, my lord. My
Where
lord,
Where is the earlier order?
my lord, it has not been admitted, my lord. It has not.
How you're telling that the returnable date is 7th of July without
My
the
lord,
matter taken by the court?
My lord, from the status report.
Well, under the.
Is it tribunal?
14 तारीख को
under the precarious circumstances may be permitted to mention one matter upon notice to the other side. But here, the illegal construction was going immediately. We have put it to the knowledge.
Civil suit.
No,
illegal construction, illegal.
No, issue is not illegal construction. But there was a stop work notice by the municipality. But subsequently, the fact your lordship
go to the determination of the municipality.
The fact, my lordship will find, here, the municipality, thereafter, the fire authority is not at all taking any steps.
Fire authority will not allow to construct.
No, not on that. Untoward incident may happen because they are stacking the material and they are using it in actual contravention of the fire laws. Anytime any untoward
What is a prayer?
Like a
What is a prayer?
Prayers are all against the fire authority.
What is a prayer? I am asking.
Presently,
Don't know.
having the petition, obviously against the private respondent as well as the fire authority to inspect the building and to act obviously
you will see to that.
kindly
give I will see to that.
No matter, this is assailing the entry of dispute by the National Stock Exchange, that NSCL, the security registry, recording that there is an admitted default. Your Lordship, this matter is covered by your Lordship's judgment in the tea company matter, which your Lordship has recently delivered. Ad interim protection. The difficulty, since my account has been declared a default, all the banks are recalling their loans, my lord. Because now it is the RBI circular says if there's one default, then all banks must recall the loan. That is the only difficulty, my lord.
They're not in consortium.
No, my lord, not in consortium. Individual loans.
There's not consortium.
There is no consortium. absolutely no consortium. We filed the writ, it is numbered. And we already started receiving the notices, my lord.
So what is your prayer?
My lord, my prayer would be to quash this default notification, my lord.
It has to be heard.
It has to be heard by the interim stage, your lordship will consider after hearing. I've served them already, my lord.
14 July.
14
July.
my solicitors coming on, they are late. I'm just
14 July. 10 matters.
Great.
Give the mention.
Yes, my lord.
I was drawing your lordship's kind attention to the matter, my lord, which was mentioned, this Monday, this Tuesday, and your lordship was pleased to, direct me once again mention, in the sense, the slip was disallowed, I am told. It was disallowed, I am the complainant in respect of an undervalue of stamps. Now, your lordship, I wanted to participate in a hearing.
Mention that.
Yes, I meant,
So what has happened to that?
it has not been allowed, I am told. I have now indicated the entire urgency and everything along with the orders, may it appear on the 14th, I shall, inform the other side, subject to your
Not
lordship.
14. Come on 16.
16.
16 within 10.
16.
May I have your lordship's kind leave, my lord? This is a matter, my lord, where it's recording of default. My lord, after that it has to be authenticated. This is to be, my lord, followed regulation 21 of the 2017 IBBI regulations. That has not been done. We have filed a writ petition, my lord. 8th was the last day when the NCLT had taken up. The jurisdiction of the NCLT comes from this recording of default and authentication. This procedure has not been followed. Your lordship has passed a, my lord, ad interim order of protection in another matter, same facts, my lord. I am led by, my lord, a senior. May I only pray?
But the NCLT has already.
But they will proceed on the 14th. NCLT has said unless there is an order of stay, we will proceed on the 14th. Now the difficulty is that this happened on the 8th. Writ petition is, my lord, before your lordship. I'm only praying if it can be taken up any time on Monday or Tuesday, my lord. I'll be very grateful because, my lord, otherwise the NCLT will proceed and this entire proceeding, my lord, will become infructuous. Only this is the.
You declared willful default.
No, my lord. This is, my lord, Form B and Form C and Form D, my lord, of the IBBI regulations, where, my lord, the default has to be authenticated. They have authenticated the NESL without, my lord, following the procedure under Regulation 21. That's the short point, my lord.
When is the date?
14th, my lord. I understand it's very difficult, my lord. I'm only praying for an indulgence.
There are several matters.
I understand that, my lord. This will not take more than, my lord.
Monday rakho 10 minutes.
I'm very grateful, my lord. And I'll be appearing, my lord, with your permission. I'll be appearing virtually. My lord senior will be there, my lord.
My lord,
Matters rakho dekh.
My lord, may I have your lordship's leave to mention?
My lord, only wanted to know the prayer, my lord. It is immediately as the need of the hour to seal the premises, my lord, and the fire authority to take steps, my lord, so that, my lord, the premises can be immediately locked. So, my lord, those contravention and serious violation can immediately be stopped, so that, my lord, any untoward incident shouldn't take place, my lord. But kindly any date, my lord, because it's a very short matter, lordship. I have gone through it, my lord. I know that's why I am making this submission. It's a very short matter, my lord. Kindly fix a date, my lord. But appreciating the urgency, my lord. But again, a Behala incident will happen, my lord. It is a structure they have, my lord. On that, my lord, again, the Behala incident will happen.
Incident will happen. Now the government is giving so much of the compensation.
But now, my lord, the government is, I believe, not that lenient.
Government is not taking care of it. The fire incident will occur.
That's why, my lord, we have made repeated representation to the fire authority, my lord.
Why the court is
At the end, where we will
be
go.
party to all these things if the administration is not taking steps.
But repeat, what can the citizen do, my lord? They can make a representation, my lord.
Yeah.
But if the authority is in hibernation, who do I come to? Obviously, the court. And that is the predicament, my lord. But kindly, any day, my lord, I'm leaving it to your lordship.
31st July.
I'm grateful, my lord. 31st.
Lordship,
My lord.
with the lordship's permission, lordship, with the lordship's permission, I was,
Mercy prayer. No further mentioning. Yes.
lordship,
My lord,
if it-
I'm praying for your, my lord, I'm mentioning virtually, my lord. My lord, I'm praying for your lordship's precious leave, my lord, to move this contempt on an urgent basis.
The impugning order is set aside and quashed.
Lordship.
Writ petition is allowed.
So grateful.
Deeply, my lord.
You are appearing for? The communication dated 22nd May 2026 is set aside and quashed. You are being given liberty to participate in that. Both same order. 2 and 3. Disposed of. Bijwa, the temper, Bijwa.
Item 4. Your Lordship was pleased to pass an order on
Item
4. 17th April 2026, Your Lordship was pleased to pass an order directing a third-party agency to conduct the test of hemoglobin meters. But this the state government found quite a long period of time to find out from its stock the unused meters. This has been detected and sent only day before yesterday. It could not be boarded by flight because the expert said that there is a possibility of battery leakage, so it should go by train. That's the arrangement made. Day before yesterday, it has been dispatched for Ames, New Delhi. Now, please come to page 10 of your Lordship's order.
Yes.
But paragraph 2022, your Lordship has been pleased to appoint Ames, New Delhi to conduct.
Acha, this one.
To conduct tests of unused hemoglobin meters and strips supplied by the petitioners to the respondents in each district under the contract. Number at page paragraph 24, your Lordship has been pleased to direct Ames to conduct the test within 4 weeks. Has not yet reached, I'm told, but the track record. If it could be extended instead of 4 weeks by 6 weeks.
Within 4 weeks from the date of receipt of the HB.
Yes, the Ames person say that they may require a little more time.
It is not yet reached.
No, it has not yet.
Who is for the other side? Have you issued notice? Have you issued notice?
Yes,
I am keeping Monday. Let the one notice be given to the other side. The matter is mentioned as has listed as to be mentioned on the prayer made by the counsel for the petitioner. Counsel for the petitioner submitted by an order dated 17th April 2023. This court directed the Ames, New Delhi to conduct test of the HB meters and strips and to submit the report before this court, but the material could not reach before the Ames, and as such the counsel for the petition pressed for extension of time to conduct the test by the Ames, New Delhi, and to submit the report. This court find that none appears on behalf of the respondent, according to petition director to serve against a notice upon the respondent is the matter on Monday under the same heading.
Item 5, there is an interim order which expires today that may be appropriately extended.
Item 5.
My lords, I appear for respondent number 5 in item number 4.
The private respondent. 4th May 2026, there was an
the matter is listed as to be mentioned under on the prayer made by the counsel for the petitioner. Counsel for the petitioner submitted the interim order is still today and paid for extension of interim order. In view of the submission made by the counsel for the petitioner, interim order is extended till 10th of August 2026 or until further order.
Obliged.
To be mentioned, to be mentioned under the heading to be mentioned. First one, Monday. Yes, next.
Would I appear for the petitioner?
That in this matter, Planet AGP and Mrs. Manju Agarwal is appearing. Kindly give me a short password.
But this is that pump matter, my lord. I had concluded my submission.
Yes.
Short password.
Pasua.
Well, in that case, kindly keep it for next week.
Next.
Monday. Retaining its position, my lord.
But in the meantime, they will take steps then.
Yes, yes. Kindly, my lord, pass some.
That's why.
Yes, some
instruction they are.
Some observation at least.
What instruction they are bringing, we don't know.
Kindly short password. 10 minutes, my lord.
Anyway, then, my lord, there is another matter fixed at 12 noon. If this could be, my lord, the second 12 noon matter.
12 noon, your matter is there?
Yes,
okay,
my
come
matter.
at 12.
I'm grateful.
Appearing for all the respondents. And as I was indicating on the last occasion, my lord, the file is voluminous. It's a very short matter. In fact, when it's covered by an order passed by your lordship, almost similar, the facts, my lord. It pertains to, my lord, the tender which was floated for bulk LPG transportation by road for Odisha, my lord, by the Bharat Petroleum Corporation Limited. Video NIT dated 15/3/25. The date of closing was, my lord, 15th of April 2025. The petitioner was issued, my lord, the letter of intent on the 10th of October 2025. There was a condition about obtaining a peso license within a period of 4 months. So that expired on the 10th of February 2026, my lord. So by that time, my lord, the peso was could not be obtained because the transfer, my lord, got delayed because of extension granted to the tank truck, my lord, by the erstwhile company, my lord. So, my lord, thereafter, my lord, despite expiry of this period, on 26th of February 2026, a show cause notice was issued, which is at page 342, and there was suspension with immediate effect. I was called upon to respond to it, my lord, within the stipulated time frame. I responded on 9th of March 2026. The irony is, my lord, while responding, there were two responses. One by way of email and the other one, my lord, by way of a hard copy. Hard copy, my lord, they are into transportation business, my lord, they have lost. But what was not considered was that even prior to the response, dated 9th of March 2026, my lord, the peso license was already obtained on the 5th of March 2026. But despite that, my lord, a termination letter, my lord, will find it is the last but one page, my lord, of the last volume, page 348. Before that, my lord, will find the peso license at page 347. It is dated 5th of March 2026.
Peso license got on 5th of March.
5th of March, my lord.
Registration?
My lord?
Registration?
Registration was made, my lord, before that.
Where is the registration?
Registration, page 346, my lord.
346.
First transfer 23, then second transfer 25.
Ownership
My lord, page 347, the date is mentioned 25th March.
No, date of renewal is 5/3/26.
That is
Date of renewal is 5/3/26. Date of expiry is 6/3/31.
Date of registration was 17. When it was transferred?
the vehicle is dated 25th
25th of
March.
26.
Peso was, my lord, on the 5th of March.
That is so far as the earlier transport contract. Not this. That 5 year is a routine extension given by the peso for all vehicles. But the
name of the registered owner, my lord, will find.
When the tender was issued to you?
But the tender was issued in the letter of intent was on, my lord, 10th of October 2025.
10th of October
2025.
10th of October 2025. Yes. Within 4 months.
Yes, within 4 months I had to obtain, my lord. 10th of February, that time
10th
expired.
of February could have been have to change all the
Yes.
peso and RC.
Yes.
Then when you completed?
My lord, I have furnished the peso. My lord will find, as I was indicating.
Peso is 5th March.
5th of March, yes.
Yes, after the February. And where registration, when it was done?
My lord, registration, the date of registration, my lord, is not available. But my lord, as far as my knowledge provides, unless and until the registration is done, my lord, the license cannot be granted. Registration is a precondition towards grant of license. But in any event, my lord, as I was stating, my lord, the termination letter at page 348.
Yes.
I will say, my lord, it merely records it ipse dixit, my lord, without taking into consideration this fact. Regarding, my lord, the peso already
The
being
so-cause
there.
notice, when you submitted the so-cause notice?
But, I responded, but I have the
26th of
email copy
February.
only. But yes, it's on 9th of March, but it is, my lord, not the hard copy, because as I find, my lord, there was a hard copy, as I find from the termination letter. My lord,
No.
will find it at page 340.
Where is your reply to the so-cause note?
Yes, 344, my lord.
Yes, I've seen it.
344 and 345. My lord, my prayers are very innocuous, my lord. If it can be sent back so that they can consider everything holistically and pass an order.
9th March.
Yes.
You sent the 9th March.
Yes.
And
There was no hearing.
no, you sent on this page 344 is the 9th March.
9th March, yes, but as
But,
I was indicating,
But your PESO license is 15th.
5th March, 5th March, that is
5th
exactly
March.
what I indicated Bharat, at the outset, that there were 2 copies, Bharat, and they have written that it is in the process.
No, transfer dated 25th March.
Bharat, if a hearing can be granted to them, Bharat, and if a order, Bharat, if a fresh order can be passed.
This is the list of dates, my lord, which will indicate, my lord, they are supposed to get this by 9th of February, my lord.
That
But
actually
they-
শেষ করে দিন।
Watch, Joshua,
I am covered by a similar order, my lord, an order passed in similar circumstances by your lordship, my lord.
not similar. Yes, thank you.
There, my lord had, my lord, set aside the order and remanded it back with a direction to grant them an opportunity of hearing and passing of a press decision.
In this case, the details
Para
are
5,
already
my lord,
done
will be
and
ready.
They were transported.
5 and 6.
For passing termination order, submit a notice.
Lines আছে?
না।
Date of registration টা যদি জানা যেত exactly.
Yes.
Well,
No,
this
that's
is
why
the-
that's why I'm asking you before the so-called reply, you admitted that it has not
No, no,
been
it is
changed.
admittedly beyond the stipulated time, my lord. But
Yes.
what I
Now
am
you are changing. Now it has been transferred.
here, it
No,
has
it
been
has been
transferred. License is already there. No opportunity of hearing was granted to me.
Okay.
It's an innocuous prayer, my lord, if it can be sent back for a fresh decision upon grant of an opportunity of hearing.
My lord, I'll hand over a list of dates.
Yes.
Yes, Joshua, there's a list of dates. Thank you. My lord, the dates which my learned friend has mentioned are more or less correct dates. My lord, they were supposed to give, my lord, produce the vehicle with all the paperwork done by 9th of February, my lord. They don't do it. My lord, after almost 15 days thereafter, we issue a show cause notice on 26/2, saying that they have not acted in terms of the LOI. LOI deadline was 4 months. If your lordship once takes the corrigendum, my lord, at page 328 of the writ petition.
And সে P2.
Yes.
Kindly comes to page 330. 330, my lord, lower portion, my lord. In case the bidder.
Yeah.
In case the bidder fails to submit the required documents with change of name, etc., within 4 months of issue, which is 9th February of LOI, suitable penal action shall be taken, which may include EMD forfeiture, caution money forfeiture, termination of order of such TTGs, and blacklisting of such TTS. Under no circumstances, this is important, my lord, under no circumstances will the above mentioned timeline be extended. In such cases, the contracting corporation reserves the right and shall be at liberty to induct TTs as per the methodology mentioned in the tender to fulfill the shortfall arising therefrom. So, my lord, this is a provision for appointing ad hoc dealers, which we have done. Ad hoc dealers have been appointed. Subsequent to their failure, my lord, to produce this document by 9th February, my lord, 26th February, my lord, show cause was issued. They give a reply, which lordship has seen at page 345 is the, my lord, 344 is the copy they are referring. 347 is the clear copy. 345 is the clear copy. This is to inform that we have this dated 9th March. Lordship will see the date 9th March.
Correct.
Have not been able to complete the process of getting explosive license of the said tanker within stipulated 120 days. We are in the process of getting the same. So it is not there on 9 March also. And we request you to kindly allow us some more time to complete the formality. So the document my learned friend was showing was 25th March document. It is 25th March when the transfer, lordship on the top, lordship sees.
Yes. 347.
Yes.
Second one.
transfer dated and thereafter transfer dated 25/3. First transfer.
That's the
was 20
PESO license.
Yes.
What about the RC?
RC, well, RC, Ballad, it's not clear from here also. This is one RC of February
That is
2017.
initially. That is the date of
2017,
registration.
that is earlier.
Date of registration. What is the date of change of ownership?
That is not here.
No,
That
it
is not
here.
because they have not replied to the show cause notice. So those documents are not with us, madam.
No,
They had to
there
come up,
was a
they had to-
response. There was a response, my lord. Kindly takes page 349 for once. It is not the email, my lord, as I initially stated, my lord, and I, my lord, rely on that what I have submitted, my lord. Kindly take para 2 of the impugned order. In so far as your explanation that the TTs remained engaged under previous tender, which was subsequently extended, thereby preventing completion of statutory processes such as ownership transfer and obtaining the PESO license, it is observed that similarly placed TTs of other contractors participating in the same tender have successfully completed the required documentation and ownership transfer within the stipulated time. So, my lord, what I have been showing, my lord, as my lord, the email response to the show cause notice is not the only response. There is a hard copy, my lord, but they are into transport business, my lord. They are as not as particular with documents, my lord, as we are as lawyers.
That document is not before your law.
Oh, okay. Oh. But I am grateful to Mr. Das for pointing out the date of transfer is 24th February 2026, page 346, my lord. Kindly takes, my lord, the RC. But horizontally, my lord, it is written card issue date 24th February 2026.
Yes.
Has my lord got it? My lord, the date?
Card issue date is that, but date of registration is something else.
Hey,
No, see, if it is date of registration, that is the purchase of the vehicle. Vehicle might have been purchased in the first part.
Right.
Subsequently, it was transferred in his name on
That transfer is not available.
No, that's why the
That
card was
transfer is
issued
not available.
24 February in his
24th.
name. Because now the owner owner name has come as a Durga Trading.
Other aspect is, my lord, lordship will see the judgment they have shown. In that judgment, before termination was issued, the trucks were already placed and they were already carrying loads. Even before show cause. But that was not mentioned in the show cause. That was the reason, my lord.
No, in that case, yes.
That was an absolutely different case. Here, my lord, it was not available till the termination also. We do not know whether it is there now also. And my lord, the other part, lordship will kindly see. My lord, the order was passed, termination order was passed when lordship will kindly see.
20 March.
20th March, my lord.
20 March.
Lordship will kindly see the date of affirmation of this writ petition, my lord. My lord, page 37 of the writ petition, my lord. 30th June. After more than 3 months. Lord, you will see page 37 bottom.
Yes.
30th June. After more than 3 months. They were waiting, my lord. So many things happened. They were.
What has happened after this order, Mr. Bhattacharya?
After this order, my lord, they
Was
came
terminated.
after
3
this order,
3
my lord,
months.
yes.
Now they're telling that the other
They are
party has
friends. And my lord, if
not
any
about
leverage
this.
is given to them, my lord, there are similarly placed people. My lord, it will open a floodgate. And this is a pan India, my lord. At least Eastern India, all people will start coming. It has to be open for everyone, my lord. The ad hoc dealers have already been appointed, my lord. They are operating in the field.
A short response. But I am, insofar as, my lord, on the perversity of the order of termination, which admittedly, my lord, as now apparent or manifest, my lord, from the submissions made by my learned friend, my lord, is, my lord, they have not taken into consideration, my lord, relevant facts, my lord. In fact, my lord, my learned friend did not even receive, my lord, the instruction as regards the date of transfer. Though it remains, my lord, that it was transferred in the month of February. Regarding the PESO license also, my lord, it is there 5th of March, but this was not taken into consideration. I am not praying, my lord, for my lord, disturbing any third party right. And ad hoc arrangements, my lord knows better than, my lord, I do. Ad hoc, my lord, the word ad hoc is, my lord, without conferring any right. So I am just praying for, my lord, setting aside of this order, compliance with the rules of natural justice, an opportunity of hearing and passing an order afresh. Let them consider and let them pass the same decision if they feel that I was at fault.
Yes.
Because I have indicated everything.
345 is the reply to the show cause.
No, no,
Where is
345 is not the solitary reply, as I have been pointing out.
there is no other.
Para 2 of the impugned order that states about another reply.
No.
Yes, because that reasons are not here. Para 2 of the yes, this was not there in the reply, the email response.
But where from it would appear
I have been
that
submitting that I have lost that copy.
these documents were ever given. The documents relied on at page 340. Yes, page 346. And the peso license which was not there, which was much after the reply of the show cause.
Kindly
How
take,
could they have given it?
kindly take, my lord, the 2 pages handed over by Mr. Mal.
Page
Kindly take serial number 5 in the second page.
Yes.
9/3/2026, reply along with other documents. This is not, my lord, the correct instructions, my lord, which has been received by my learned friend, because there were other documents which were submitted with the reply.
346.
It is not the solitary email, my lord, that I have been submitting since inception.
That is the only document.
This
346.
cannot be the only document. Where is the
Yes.
other document?
That is
Okay,
only
okay. Yes, anything further?
No, my lord. My lord, only one thing, my lord. At page 348,
Yes.
if your lordship sees the reference part,
Hmm.
we have considered your reply dated 9 March.
Correct. 9th March.
And issue, my lord, there is no scope of setting aside the termination order. My lord, they are coming after more than 3 months. They are really fence sitters, my lord. Look, this will really create a
Yes, Mr. That is the only thing with regard to after 3 months. Why you not come immediately after the termination?
Well, a month was lost, my lord, because
3
of
months, then they have taken their dog and
there were
how
other
that-
matters.
so ad hoc, my lord, ad hoc
Petition
arrangements.
bench and all.
Ad hoc arrangements.
I am not setting aside, but I will direct you made a fresh representation.
Very good.
If they've considered your document, then
Very, very, extremely grateful.
Lordship.
the petitioner has filed the present date application challenging the impugned order dated 20 March 2026, wherein the treaties number OD 058 into 3600 are terminated with immediate effect for failure to submit the RC and PESO license within 4 months from issuance of the LOI as mandated by the corrigendum dated 4/4/2025. Learned counsel for the petition submitted the LOI was issued on 9th of October, 10th October, on 10th of October 2025. The petitioner has to transfer the PESO license as well as the registration, as well as the ownership of the registration of the vehicle within 4 months. After getting the LOI, the petitioner has applied for transfer of ownership in the registration, ownership of the vehicle in question as well as the PESO license, but the same was pending. In the meantime, the respondent authorities have issued the so-called notice to the petitioner as to why the LOI issued to the petitioner shall not be terminated, as the petitioner failed to transfer the ownership of the vehicle as well as in the PESO license. The petitioner has submitted a reply praying for some time as the transfer of the ownership and the PESO license is under process. Considering the representations, considering the reply submitted by the petitioner, the respondent authorities have passed the impugned order by terminating the contract for violation of the terms and conditions, as the petitioner failed to transfer the ownership of the RC, of the registration and the PESO license. Mr. Bilawal Bhattacharya, Leonard Senior Advocate appearing for the petitioner, submits that though on the date of issuing the so-called notice and filing the reply, the registration of the vehicle and the PESO license could not be transferred in the name of the petitioner. But subsequently, on 25th of February 2026, the registration of the vehicle was transferred in the name of the petitioner, and the PESO license is also transferred on 25th of March 2026. He submitted as present the petition is having the valid document to show that the registration of the vehicle and the PESO license in the name of the petitioner with respect to the vehicle in question. He prays for a direction upon the respondent authority for setting, he prays for setting aside the impugning order and direction upon the respondent authorities for consideration of the request of the petition as a fresh. Learned counsel appearing for the authorities, Mr. Bhattacharya has relied upon the judgment passed by this court in the case of in WP 7477 of 2026, Messrs. Sevak Enterprises versus Union of India dated 3rd March 2026, wherein this court has set aside the so-called notice and directed the authorities to consider so-called notice and the impugn order of determination and directed the respondent authority to consider the case of the petition in accordance with law. Per contra, an advocate appearing for the respondent authorities raise objection and submit that the petitioner failed to get the registration of the vehicle transfer in his name and registration of the vehicle as well as the PEPSO license in his name within 4 months. To give an opportunity to the petitioner, a so-called notice has been issued, and in the so-called notice also the petitioner has admitted that the vehicle has not been transferred, vehicle as well as the PEPSO license has not been transferred in the name of the petitioner. He has relied upon the corrigendum of the terms of the contract, wherein it is mentioned that in case the bidder fails to submit the required documents with change of name, etc., within 4 months of the issue of LOI, suitable penal action shall be taken, and accordingly the respondent authorities found that the petitioner has not get the vehicle transferred in his name, vehicle as well as PEPSO license in his name, according the impugn order is London Council for the respondent further submit that the impugn order is passed on 20th March 2026 and the petitioner has filed a present application in the month of June 2026. In the meantime, for the interim arrangement and ad hoc transporters have been appointed in place of the petitioner to a smooth functioning of the business of the respondent authorities. Police. Had the learned counsel for the respective parties peruse the materials on record. It is true that as per the LOI, the petitioner has to get the license, registration certificate and the PEPSO license transferred in his name within 4 months from the date of LOI. It is also admitted that within 4 months, the license and the PEPSO license has not been transferred. And the petitioner in his fair way in the representation has requested inform the authorities. Fair way in the reply to the so-called notice, inform the authorities it has not been transferred, but it is under process. But the respondent authorities have passed the impugn order on 20th March 2026 as the vehicle and the PEPSO license has not been transferred in the name. This court find that the petitioner has disclosed the document, that is a registration certificate of the vehicle in question, which reveals that on 24th of February 2026, the vehicle has been transferred in the name of the petitioner and the PEPSO license has been transferred in the name of the petitioner on 25th of March 2026. Considering the above, the respondent number, considering the above, the petitioner is requested and directed to make a detailed representation by mentioning the all circumstances to the respondent number.
Well,
Want to work for it?
4. It will be one of the respondent.
Respondent number 5. Respondent number 5. 5. And if any representation is made along with the all documents by the petitioner, the respondent number 5 shall consider the request of the petitioner and pass the appropriate order within a period of 4 weeks after this.
But upon an opportunity of hearing. Next. Great.
On the last location, your document.
Yes.
I may be allowed to use affidavit.
Huh?
I may be allowed to use affidavit in opposition, my lord, in this matter.
What is the matter?
This is the disciplinary proceeding matter, your lordship.
That one.
Is the issue
Yes.
information, anonymous information, subsequent withdrawal.
Yeah,
Despite
that was hard.
My lord, it was hard. My lord allowed me to take instruction. I have obtained instruction. My lord, it is at 21B stage. That is under section 21B stage. Because after prima facie opinion is there.
Only the question is that as far as my knowledge goes, goes, that if the complainant is not available on the basis of which the case has been initiated, a proceeding has been initiated against the petitioner, if the complainant is not there, whether the proceeding initiated can be proved or proceeded against the petitioner further, and how you can prove if the original, if your buildings, the main base is not there, how your building will go up?
May I answer, my lord? My lord, this information case, what is
Now,
it?
I appreciate your case is that, okay, the complainant is not there, but on receipt of the complaint, you have gathered all the documents. From the document, you found that, yes, there was.
Actually, lordship will appreciate that it is a quasi judicial proceeding. The strict sense, the Evidence Act and the IPCF, it is not applicable. What is
Preponderance of probability.
absolutely, madam, preponderance of probability. Now, the information which you are supplied, and thereafter we have downloaded the document.
Okay,
we
file.
have then which we are deeply.
Okay, file.
I will bring on record what is the actual state.
Let
It is proceeding is pending before.
Learned Counsel for the respondent request for time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks.
4 weeks, madam. Because instruction will come from Delhi.
4 weeks, reply if any, that will be filed within 2 weeks thereafter. List the matter.
Your lordship, the interim measure in para 3 of last order should be continued. Your lordship. That is
Let the matter appear on 26th of August 2026 weeks. Na? 26th of August 2026. Full stop. In the meantime, the respondent is directed not to proceed with the proceeding till the next date of hearing.
I'm deeply obliged. Your lordship has passed a direction for reply as well.
2 weeks. 4 weeks, 2 weeks.
May it please your lordship, I'm for the petitioner. This is the payment gateway account which was frozen by IndusInd Bank, the current account. My lord, in the last occasion, your lordship was pleased to pass a direction upon us to serve notice to the police authorities. My lord, an affidavit of service to that effect.
Served, delivered.
Delivered, my lord.
They are not appearing.
They are not appearing, and my lord, in that notice itself, we gave a detailed tabular sheet. In the second page of the notice, a detailed tabular sheet of all the cases, refer acknowledgement numbers, the states and the police directorate. And requested them to also come and appear and file reports.
Yes.
And my lord, also the bank was supposed to file.
Yes, who is appearing for the bank?
My lord, I am appearing virtually, my lord. My junior is there. The report is with her. She shall file it.
May I have a copy, lord?
Yes, your lordship. My lord, the total amount is very meager. It's only the disputed amount is only 76,000 something. So, my lord, my instructions from the bank are that we have no problem if the orders of defreezing are passed.
72,000.
So how much amount is lying in the account of the petitioner? 3 lakh.
My lord, it is about 1 crore 33 lakhs.
Lying in your account. You not stated anything in the report. What is the total amount lying? You have given the disputed amount 72,000.
Yes, your lordship.
Lying that has not been given. So I am disposing of keeping this disputed amount in late.
Yes, your
Authorities are not appearing. What can be done?
Yes, we are grateful, Your Lordship.
The petitioner has filed the present writ application praying for a direction upon the respondents number 227 to defreeze the current accounts. How many accounts?
One account, Your Lordship.
One account.
One account.
One account.
The current account of the petitioner lying with the IndusInd Bank, Savitri Tower branch, Kolkata. Full stop. The petitioner submits that petitioner is maintaining the current account with the respondent bank, that is
IndusInd Bank.
the respondent number 3. That is the respondent number 3. All of a sudden, when you came to know about the freezer of the account?
My lord, first we came to know in July 2025 and then again on.
No, no, my lord, that is probably not true. It is in January 2025 that they came to know, because they have filed another writ before this writ also. That was disposed of. So they came to know in sometime in January 2025.
To my knowledge.
The petitioner submits that initially the bank account of the petitioner was freezed by the bank in the month of January 2025. And thereafter, the petitioner has made several requests to the authorities, and the authorities have submitted that the account of the petitioner is freezed by the bank on receipt of the several complaints from the from the National Cyber Crime Reporting Portal. Full stop. This court directed the bank to submit the report. Accordingly, the bank has filed the report after serving the copy to the Land Council for the petitioner. From the report, it is found that altogether there are 11 complaints received by the petitioner through the received by the bank through the National Cyber Crime Reporting Portal of the different states. Out of the 11 complaints, 2 complaints have been fully resolved. And at present, the total disputed amount is rupees 72,939. 939. Full stop. In terms of the order passed by this court, the petitioner has sent the notice to all the investigating agencies on the basis of the report. The bank has freezed the account of the petitioner. The petitioner has filed the affidavit of service showing the notice has been duly served to each authorities, but none of the authorities are present before this court in spite of service of notice. Full stop. As none, full stop. The only case of the respondent bank is that the bank has received the complaint through the portal. Accordingly, the bank has freezed the account of the petitioner. It is not the case of the bank that the bank has received any order from the investigating agency from any competent court of law for freezing of the account. It is the specific case of the bank that the bank has freezed the account only on the receipt of the report from the portal of different investigating agencies. Considering the submission made, full stop. This court finds that the only disputed amount is rupees
72,939.
939 rupees. And due to which the total account of the petitioner has been seized, and the petitioner is not in a position to operate the said bank account. In view of the above, full stop. In view of the above, the bank is directed to keep the disputed amount of rupees 72,939 on lien, and to allow the petitioner to operate the bank account with respect of the undisputed amount, and to operate the bank account without any further In view of the above, the bank is directed to keep the disputed amount of rupees 72,939 and lien and to allow the petitioner to operate the bank.
With immediate effect, Lordship. With immediate effect,
Yes,
Lordship.
immediately, with immediate effect. WPS disposed.
I'm grateful, Lordship.
Next.
Gratefully, Lordship.
Your Lordship, 10 is an SIR matter.
Yes.
Page number 49 is the appeal.
Page number?
Number 49 is my lord, the acknowledgement submission of appeal.
49.
49 page, last annexure, my lord.
Yes.
Urgency is that, my lord, the petitioner is a contractual worker of urgency is that, my lord, urgency is that, my lord, the petitioner is a, my lord, contractual worker of a Gram Panchayat, and my lord, his baby is aged about 6 months, and she wants, my lord, urgent medical treatment of his eyes, my lord, of her eyes, and she the
medical treatment.
Yes, my lord, and he will.
How many petitioners? Sole petitioner.
Sole petitioner, my lord. And he will take her baby to Nepal for eye treatment, my lord. To Nepal for eye treatment. That's why, my lord, this is the emergency.
Yeah, treatment. The hospital is not giving the treatment to you because of the.
No, my lord, he is in apprehension. He might be, my lord. He might be prevented in border, my lord.
Who?
The petitioner. That's why, my lord.
Who will prevent you?
Maybe, my lord, but that
maybe
is, my lord, only my lord.
The petitioner has. Yes, madam.
Your Lordship, there's no documents pertaining to the medical records. There's no document in the petition or about.
The petitioner has filed the present date application with the grievance that the petitioner has filed an appeal before the SIR Appellate Tribunal against the order of deletion of his name from the voter list. But the appeal is pending and prays for a direction upon the appellate authority for disposal of the appeal filed by the petitioner dated 6th. When you filed?
8th April 2026.
6th April 2026. Consider the submission made by the counsel for the petition. This court find that the appeal filed by the petition dated 6th April 2026 pending before the SIL appellate tribunal. Accordingly, the appellate tribunal is requested to consider the appeal filed by the petition to dispose of the same as early as possible, preferably within a period of 3 months from the date of receipt of this order.
I'm getting close.
Yes. Affidavit. Next. ये आज के SIR नहीं ये क्यों बीच में आ गया? यस हाँ 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 तो Rampur had Cooperative Agriculture Bank. Yes. Then huh? So what is the prayer? Without 191 they invoke 190 allow that also I have already to that amount. And here is still nothing. So it is a cooperative bank. Yes. So why before the court? Why you not go went to the registrar of cooperative society under the arbitration? Under the Cooperative Society Act, the registered cooperative society will deal with the matter. To whom? All the bodies. The chief manager to up to the chairman. No, have you given the registrar of cooperative society? Niranjan Kumar, I guess, registered cooperative society, cooperative cooperation department, the secretariat building. You have a cooperative act? Yes. Cooperative Societies Act? Yes. So there is a provision might be. There's no provision. Access jurisdiction. Good. Shortcut method. Where is the 192?
And it is not there. That is 2006 Act, and subsequently this is rules. This one is rules. 2011 rules.
Where is the notice? Who is appearing? You are
Lord,
appearing.
I am not appearing, my lord. I am not.
Because nobody is appearing. How the matter can be
My lord,
taken?
your lordship can engage us, my lord. Take instruction.
Yes. You will appear.
I'll appear along with Mr. Benedict.
You do one thing, give the copy. The petition is directed to serve the first copy of the writ application along with the documents to the learned advocate appearing for the state. So the state is directed to take, and the learned advocate appearing for the state is directed to take appropriate instruction. You one copy.
Give one more copy.
अरे one copy. क्या बोला? Directed to take instruction. Let the matter appear on 28 July.
I said another notice. And under 120.
Come on 28. Next. Directed to file report by way of affidavit to ascertain whether the premises number 23 Harbor Solutions is available at the site or not. If not, how the market value of the premises was ascertained at the time of registration of the conveyance. Yes.
My lord, let them. I know, my lord, the lordship can appreciate in the office of the GP was not functioning properly. You give a copy. I know. Yes. No. No. I'm telling you, last 1 week on it has been
Now I got the permanent AGP is here.
My lord, Miss Banerjee would be there and I'll come. You give a copy, I'll take instruction and copy of the order. And your lordship will record my our appearance, my lord.
And press for time to take instruction. Accordingly, petition is directed to serve the copy of the order. You have a copy of the writ petition along with the documents and the order dated 13th April 2026 to the learned advocate appearing for the state respondents. The learned advocates are appearing for the state respondents are directed to take appropriate instructions in terms of the order dated 13th April 2026. Let the matter appear on 29th. That's why in terms of the order dated under the same she's appearing.
My lord, I am appearing on behalf of the enforcement. Then
In item 13, Mr. S.B. Raju is appearing on behalf of the ED, I mean led by him. It's just for withdrawal of the petition.
Withdrawing?
Yes.
He will not press. Yes. Learned counsel for the petition handed over a communication dated 27th of June 2026 received from the petitioner, wherein the petitioner has informed the learned advocate of the petitioner that the petition is not intending to proceed with the present writ application and press for withdrawal of the writ application. In view of the submission made by the counsel for the petitioner and the written instruction WPA 12109 of 2026 is dismissed as withdrawn. In written instruction, we copy the record. Interim or defendant.
I'm able to state your lordship. No, state.
Yes.
On behalf of the respondent number 225. All have become a retainer for the state, he cannot appear. Just kindly.
When? Next week? As per the prayer made by the counsel for the petition, case is adjourned. Let the matter appear on 23rd.
23rd.
Then 29th come. 29 under the same heading. Next.
Let the after your lordship fix the date today, that my client has got a call from the passport office. Now, he wants to go to the passport office and meet him to resolve the issue on Monday.
So I am adjourning the matter.
Yes, sir, you can, lordship can adjourn it.
After a week?
Next week, Tuesday.
As per the prayer made by the counsel for the petition, let the case adjourned. Let the matter appear on 16th.
16th. No, not 16th, 17th.
You are not 17th. Then come on 20.
Yes, deeply applied. By this time, I think the problem will be solved. Problem will be solved. Let 16 I appear for the petitioner. The case is that I am in custody since 1997. My brother who expired, who was in custody, the wife of my elder brother who was in custody, she got, kindly have a look to the order passed by the superintendent, page 21, the detention certificate and premature release. But it is in case of Podda Rai. He is one of page 21. Got it?
Padma Roy.
Yes, Padma Rai. This to certify that the below mentioned female convict prisoner with following details, so and so, the behavior of this so and so.
When
the life convict is released as per the order of the governor, Video Judicial Report number so and so. But she was released after the serving the period of detention 17 years, 11 months, 28 days. Now, I am in custody for more than 20 years. But I made.
You are the co-accused.
Co-accused. But my brother.
How many accused per
three? My brother who expired during Corona. Me.
In the custody itself.
Yes, in the custody itself. And I got a parole because of my behavior, which I have annexed. But if your lordship kindly have a look to page 29, annexure P2, temporary release on parole for 10 days.
Yes.
But I made representations to the office of the governor and the other officials. If your lordship kindly.
Yes, who is appearing?
My lords, we are led by Mr. Majumdar, learned double AG. So, my lords, prayer on page 11.
No, but I think CS produced one document on earlier. 44 names has been forwarded. Whether this petitioner's name is there or not.
I'll find out, my lords.
Because
I'll take instructions on this.
Yes, CS 48 or 49?
No,
40 live convicts name has been forwarded to the review committee, state sentence review committee. Whether this petitioner name is there or not.
I'll find out.
You have the copy of the list?
I don't have.
So
I'll arrange for it. I'll find out if he's already. My lords, only thing is his prayer is very limited to consider the representation.
Correct. That's why if the name is already under consideration, I will dispose of this.
Okay.
Correct.
I'll take instructions. Great.
And counsel for the state prays for time to take instruction whether the name of the petitioner was taken into consideration for premature release or not. Let the matter be appeared on 22nd.
Yes,
22nd. Affidavit service, capital report.
Great.
Next.
I appear for the petitioner.
Yes.
So this millet is against millet. I've served millet. May I file the affidavit of service?
Then you have to serve it again. No. अरे कुछ होने से ये कॉपी तो चाहिए यार।
अरे कॉपी में देता हूँ कुछ बोल थे वो सुनो तो करी मैटर
मिलोड सर
कॉपी नहीं है क्या
नहीं
My learned friend appears. This is really against a blacklisting of the petitioner. Very short facts, but my learned friend says that
after change of panel, Milord, so Milord, he has given me copy right now.
no, we had served. We are serving it again on request.
I know you have served it previously.
Very well, my lord.
I know.
The petitioner has served the copy of the writ application along with the document to the land council appearing for the estate. Land council for the estate prays for time to take instruction. Let the matter appear 24th.
24th, very well, my lord. Tuesday. My lord, I have wished to annex one letter, my lord. May I'll bring a supplementary affidavit and
give the
serve a
copy.
copy. Only one letter, which is
Give.
24 same ending. Next.
Yes. Lord, I am for the petitioner. It has been served, my lord.
No notice was served also. Yeah.
This is, my lord,
Regarding OCI.
my lord, sir, affidavit of service is being prepared, my lord, although my still understanding friend has
one
been.
particular Milord,
You are appearing, Mr. Trivedi, or
Milord, I have been because I have stepped into the shoes of the learned ASG. I've taken charge yesterday. Milord, I am new to this matter, but Milord, I have got two.
now you are welcome at the ASG.
You all welcome him. And may I indicate for the
Milord, my first submission, I'm not being a submission, I'm asking my learned subject to whatever falls from your lordship. Milord, as far as paragraph 18 is concerned, lordship, they have stated that they are challenging the virus.
No.
May I indicate? I'm new to this, matter. Kindly let me. Because whatever. My lord, will kindly
Not at
see
all, not at
paragraph 18 at page 11. Lordship has.
Yes.
Got it. May I place it? The rejection of the application for updation of OCI card of the petitioner without exhausting the statutory requirement of providing a reasonable opportunity of hearing to the petitioner, the OCI card holder under the proviso of subsection F of section 7D of the Citizenship Act 1955 is ultra virus section 7D and out to be immediately struck down by this honorable court. Now, this particular statement or submission or averment, whatever they are, is not being substantiated by the prayer.
No, with prayer there is nothing.
There is nothing. So, my lord, I want to understand. I'm asking a question because if it is a virus challenge issue, they want to amend their prayers, then they have to follow the paraphernalia of giving notice to the AG.
Yeah, may I indicate? This is the loose usage of words. Actually, my lord, actually, what has happened, my lord?
I have taken it seriously. You have used it loosely.
May I just indicate the issue, my lord? My lord, the petitioner is a Spanish citizen. He is a OCI card.
Be careful for using loose.
No, that is another thing. I have taken it seriously. He has used it loosely. And if my lord takes it seriously, then he'll be in serious trouble.
Serious trouble, yes.
In those circumstances, my lord.
Yeah, just indicate, my lord.
Then it will be difficult.
This is absolutely very simple matter, a very simple case, my lord. My lord, the petitioner is a Spanish citizen. His passport, he is OCI card holder, my lord, by marriage, my lord. His marriage is still subsisting. By the passport was renewed, and the OCI card has to be updated with the new passport. Otherwise, the OCI has no value. But when the passport was application was given for renewal, after some time this application was rejected on the ground that we could not provide the joint declaration of marriage. My lord, there has been a legal strife between my wife and me and my wife regarding custody and various other matters, my lord.
Hey, one matter. He has filed one matter. You dealt with one matter. That matter.
No.
Not allowing to enter that he is in Geo until the item. Yes.
No. But this is absolutely separate, my lord. But then my lord, this according to
according section 7DF, proviso to section 7DF, a reasonable opportunity of hearing has to be given to him before any steps can be taken for regarding OCI, my lord. No such hearing has been given. And my lord, I had given all the documents showing that the marriage is subsisting. But even then, they have rejected. That is the only crux, that reasonable opportunity has to be given. That's it. A reasonable opportunity may be given and the problem will be solved. And yes, ma'am.
Take instruction. So simple.
So very simple. Very now.
So loosely.
It became complex because of the loose draft thing.
Right.
Otherwise, maybe if it could have been, I would not have even been engaged, because if it is,
It is really
What
good.
about the see, AG has come.
Yes, it is very good that.
Thank you for you to bring the AG before this court.
it is always that.
Yes.
Before your what I'm submitting is he is restricting his prayer just to consideration of the representation list. My millet, may I come back?
That's what I'm telling. Take instruction, come on that day, and I will record his submission on the next day. That he will. On the Leonard ASG has drawn the attention of this court to paragraph 18 of the present writ application, wherein it reveals that the petitioner has pleaded that Section 7D of the Citizenship Act 1976 is ultra vires and is out to be immediately struck down by the court. When the Leonard ASG has pointed out the said paragraph, Leonard Counsel for the petitioner submit that by mistake the said averment has been made, but the petitioner is not challenging any virus of Section D of the Citizenship Act. The counsel for the petitioner submitted only the grievance of the petitioner before this court, that the petitioner may be given an opportunity of hearing so that the petitioner can prove that still the marriage is subsisting. Leonard Counsel for the Leonard ASG prays for time to take instruction. According cases adjourned, let the matter appear on 27th. 27 July?
27 July. Yes. Much of it.
Any other date?
28 July under the same heading.
Much of it. Let it retain its question.
Next.
Phone number नाम खाली दिस तो हमारा नाम दिस नहीं था.
This matter relates to one or more accounts, my lord. I'm maintaining a saving accounts with the respondent bank.
Mule account?
Yes.
Who is for the bank? Which bank?
ICICI.
ICICI Bank.
But it should be.
How many accounts? One account?
No, in respect of my lord, item number 19, one accounts, and respect to item number 20, three account. No, three accounts.
19 and 20 both are same.
Both the same bank.
Item number?
But it is 19.
It is 19. It is a 19. 19 which bank?
The same bank.
It's also the ICICI.
Yeah, same bank.
That is also same bank.
Later take instruction.
Take instruction.
Yes. And but my lord, the RBI guidelines says, I think, my lord, it should be, my lord, considered that bank should inform.
Correct. That's
Yes, yes.
because on the last day also, I directed the bank to file report whether it has been informed or not. So you file the report. Leonard Counsel for the 19 and 20 Leonard Counsel for the bank prays for time to file report. Accordingly, the bank is directed to file report within 10 days after serving the copy to Leonard Counsel for the petitioner.
Yes.
The petitioner's liberty to take exception to the report, if any, within a week thereafter. Release the matter on 4th August.
4th August. Right. 19 and 20, same order. 19 and 20, same order.
19 and 20, sir. Take
But
both.
kindly take this matter analogously, my lord.
Yes, that's why you recorded.
My lord. Right.
Yes.
But here, it's a peculiar case where my father, I'm a married daughter. My father expired in 2024. But my while in service. My mother has applied for registering my name. If your lordship kindly have a look to the first document which I want to show before your lordship, the legal heir certificate. If your lordship kindly have a look to page 17. Page 17, yes. No, for the first time. This is for the first time.
Give one copy. Give
one copy.
Very. Well, we'll have a
What's
copy.
the prayer?
The prayer is very simple and limited. But if your lordship kindly have a look to page 17 once,
yes,
it said that last paragraph. The aforesaid legal heir, my mother's name is there.
Yes.
The deceased is entitled to get ADR pension, so and so. The deceased left behind his married daughter, namely Namrata Datto, who is not the relative of the family of the deceased as per relevant rules. Now, the wife of the deceased, that is the widow, is entitled to receive the benefit of family pension. But I'm not on family pension. I'm on a different aspect. Then your lordship kindly have a look to page 18, 18. 5th of March 2025, the Joint Director Land Records is writing this letter to the District Land and Land Reforms Officer, Dokhin Dinajpur. Prayer for employment assistance on corporation ground submitted by Namrata. Namrata is the petitioner.
Which department?
Well, this is Land Department.
Whether it is a determination of this court.
This is regarding enlistment of the petitioner's name in the list of legal heir certificate. That is the case. Legal heir certificate. In the legal heir certificate, only my mother's name is there. My name has been left out
because you are a married daughter.
You are a married daughter.
Belongs to the land department. This belongs to the land department, my lord.
No, this is not. Is asking with regard to the legal heir certificate.
This is legal heir certificate.
The petitioner has filed the affidavit of service. Let the same be kept with the record. The petitioner also served the copy of the writ application along with the along with its document to the learned advocate appearing for the estate in the open court. Non-counsel for the estate is directed to take instruction. Let the matter appear on 29 July
20.
Next.
বলে দিই আমরা অফিস সার্ভিস করে চেয়ে নিন
urgency खोलिए
ফোন করে দেবো ডিপার্টমেন্টের লোক আমার সঙ্গে যোগাযোগ আছে মামলা করছে
None appears on behalf of the petitioner. No accommodation is sought for. Let the matter appear in the combined monthly list.
Let a copy of the petition be served, my lord, in the meantime.
Monthly list of August 2026. Next.
Your Lordship, 23, I appear for the petitioner. Your Lordship, this matter is of 2027. 17, sorry.
My lord, I appear on behalf of the respondent number 22224, my lord. My lord, these matters come at my instance, my lord. I have, my lord, filed an application paying for, my lord, passing of an appropriate order, my lord. What has happened?
Who are you?
My lord, I am Airports Authority of India.
You're not the party here.
Yes, my lord, I am the party. I am the party here, my lord. In 2017, my lord, a writ petition was filed against the Airports Authority of India, for which, my lord, passed an order under section 28G of the AI Act 1994 for the purpose of eviction of the petitioner and for the purpose of recovery of dues to the tune of 13 crores. Now, my lord, so far as section 28G is concerned, my lord, this is, my lord, akin to the provision of Public Premises Eviction of Unauthorized Occupants Act, my lord, which is, my lord, applicable to premises belonging to central government and other things undertaking. And so far as, my lord, AI Act 1994 is concerned, my lord, they have, my lord, separate provision which is, my lord, parameter to PPA, Public Premises Eviction of Occupants Act. Now, my lord, as your lordship is well aware, Under such act, my lord, there is then provision for appeal before the appellate authority. At that point of time, my lord, appellate authority was, my lord, situated at Delhi. So, my lord, what happened? Immediately after they have suffered the order, they, my lord, approach the appellate tribunal in the appellate tribunal before Delhi, appellate tribunal in Delhi. Now, what happened? As the appellate tribunal was, my lord, not functional, they, my lord, filed a writ petition, praying for a direction that let there be a direction before to the central government to appoint a chairperson so that the appeal can be heard. And till the time, my lord, appeal is not heard, let there be an order of stay. Now, my lord, what happened after, my lord, hearing, this honorable court was, my lord, pleased to pass an order till the time, my lord, appellate authority is not functional or not functional. There should be an order of unconditional stay, subject to deposit of 4 crores as workable measurement. Now, my lord, what happened in 2021? In 2021, amendment, my lord, came in the Airports Authorities Act. 28K. My lord, kindly see 28K, and my lord, kindly pardon me, it's written, but my lord, marked. Any person agreed by an order of the eviction officer under their chapter may, within 15 days from the date of such order, prefer an appeal to the High Court. So, my lord, the word tribunal, my lord, has been substituted as High Court. So, my lord, they should have immediately, my lord, after this amendment, my lord, came into picture, they should have, my lord, filed the appeal before this very honorable court. So, my lord, now from 2017 to 2025, my lord, they are, my lord, enjoying the order of stay. An amount of rupees 4 crores, my lord, is lying deposited at this honorable court, my lord, and it's about public money, my lord. They have, my lord, not taken, my lord, any steps. So, my lord, my prayer before your lordship is either your lordship, my lord, kindly, my lord, vacate the interim order so that, my lord, we can take steps legally as per law, or your lordship, my lord, may permit us to, my lord, at least, my lord, withdraw the amount which is, my lord, lying deposited in this court, if they, my lord, choose to prefer an appeal.
Yes.
Your Lordship, my writ petition itself is the appeal. Any section or amendment cannot be with the retrospective effect. I had filed my writ petition in 2017, and the interim order was passed in their presence, and I had accordingly deposited in terms of the order, deposited 4 crores with the authority before the Honorable Registrar. Now,
Yes.
Your Lordship, it's subsequently there has been certain orders by the on the same issue under arbitration, and thereafter by the Honorable Supreme Court, that I need to place it before Your Lordship by way of a supplementary affidavit. And this writ petition itself can be heard out. No further fresh appeal is required to be filed under 20K, because this writ petition has been filed before this Honorable High Court.
My lord, kindly comes to the prayer portion, my lord, page 61 of the writ petition.
As on that day, that prayer, what was relevant for me in terms of the unamended section, I had prayed that. Your Lordship, this was a case wherein I was the sole ground handling agent for the Calcutta airport, wherein certain open area, open to sky, was given to me for keeping my equipments.
Oh, no, after the amendment of 2021. This amendment was when 2021.
Yes, my lord.
After the amendment of 2021, whether still the appellate tribunal is there?
No, my lord.
No.
Because, my lord, since, my lord,
because now 28K is amended, it is to the High Court.
Yes, ma'am.
Prior to that, it was the appellate tribunal.
Appellate tribunal, my lord.
Correct. Now, after the amendment, appellate tribunal is there or not?
No, my lord. It's
There's
not
no
there, my lord.
appellate tribunal.
It's not there.
So there's no question of appeal now.
No, my lord.
And they have challenged the order of the state officer.
Your Lordship, we have.
Whereas the scope of this writ petition is concerned, my lord, as my lord, to subject to, my lord, correction by your lordship, my lord. My lord, kindly comes to the prayer portion. Prayer A, page 61.
Yes.
Writ of and or in the nature of mandamus be issued, commanding the respondent number 1 to appoint a chairperson constituting a quorum of the airport authority tribunal under 20I.
That's why now that is over.
That is
So
over.
that cannot be done now.
Right.
Now commanding respondent when agent to the impugn order. So now this is to be taken as an appeal.
So if
Now
you,
this
so
repetition
I
is
will,
third
I will
and
not stand in way. If your lordship my lord takes this as an appeal and my lord,
because now the one prayer A has become infructuous in terms of the amendment.
Right, my lord.
Pendency of the
Right,
writ application.
right.
Now, as on date, there is no tribunal.
There is no tribunal.
Now, as per 28K, this court has the jurisdiction to hear the said appeal. So, whether the writ petition is to be treated as an appeal against the order.
That
Your lordship, my other prayers are there. Those
Yeah.
are, your writ court has ample power to modify such prayer in by way of a supplementary affidavit. I'll put in those relevant prayers.
Affidavit in opposition, my lord. This is my lord, my affidavit in opposition, my lord. That
Whether
was not.
affidavit is completed.
Your lordship, I believe all the pleadings are completed.
I am fixing a date if the pleadings is completed.
Your lordship, I will file a supplementary affidavit so that with the change circumstances, I can place Supreme Court's order as well.
File it.
My lord, may I be
There is no
permitted to?
affidavit here.
My lord, may I be permitted to file my affidavit in opposition, which was my lord affirmed way back in 2018.
Have you served?
Yes, my lord. I have served, my lord.
They are not
My
filed
learned
as-
friend could provide again the scanned copy. I'll check the records with the reply.
But no,
I believe
not-
we had served them a reply, but it may not be on the record because this is the first time it is coming after the interim order.
The matter is listed. The respondents have filed the application being Can 1 of 2024, praying for appropriate order for disposing of the instant writ application as early as possible. The counsel for the respondent has also drawn the attention of this court, section 28K of the Airport Authorities of India's Act 1994, wherein which reads as follows. 28K Koridin, huh? He submits that now there is no he further draw the attention of this court to prayer A of the writ application and submit that now the prayer A cannot be allowed as there is no appellate tribunal in terms of the amendment provision of section 28K of the said act. That counsel for the petition submit that the petition have made several other prayers in the writ application and this court can dispose of the writ application after completion of the pleadings. The respondent has filed affidavit in opposition. Let the same be kept with the report. Serve the copy to the petition.
But I have already started.
One copy. The petitioners are given liberty to file reply within 2 weeks. Police Learned Counsel for the petition further submit that the petition will file supplementary affidavit to the subsequent events of after filing of the present date application. The petition is given liberty to file supplementary affidavit by disclosing the documents, if any, within 2 weeks from date after serving the copy to the counsel for the respondent. The respondent is also liberty to file affidavit in opposition to the supplementary affidavit, if any. Full stop. Let the matter appear. Give the date. So I am fixing for hearing.
Your lordship.
Let the matter appear on September which date? ट्रैक करके रख दो ना जो खाली 9 September at 2 PM as specific.
For time. Grateful, man. Grateful.
Let the book with me. You tell the
yes, yeah.
Yes, next.
This lordship will remember the form C for the NESL authentication was submitted in April 2026, 8th April. Lordship, this lordship may find that it will come back to my lord page 173. That is, the bank has to submit the form C to NESL. NESL then gives us intimation. This is a lordship will see top right hand corner, second row, submitted date and time on the right hand side, 8th April 2026, 20:00,
115. I give my reply, this is going on. Now, all of a sudden, we come across this page 5, page 194. I've given my dispute notice, they have come back, page 194. Row
Rejected.
Row K, authentication completed on 20th September 25. Well, the note, so this is what, if now whatever steps will happen as per Form C, that will be in accordance with law. Have you given the regulation?
Authentication completed on 20 September.
But we had handed up the regulation, the utilities.
Who is appearing?
My lord, I represent the State Bank. Although I've been made a pro forma respondent, my lord, I'm gravely affected, my lord, by these proceedings. Reason being that, my lord, orders here, my lord, are being used in the NCLT to try and scuttle, my lord, the insolvency petition that is pending by a defaulter who's, my lord, defaulted, my lord, crores of rupees in excess of 17 crores. Now, my lord, in the NCLT format, my lord, where a petition is filed, the, my lord, records of the information utility are only, my lord, one of the things which are to be filed. Section 7 as it stands, my lord, a person can prove his debt irrespective of whether there is the information utility record or not, because that's only one of, my lord, the ways of proving the debt. There are other ways of proving the debt, and, my lord, default is evident from, my lord, what we have. So very well. So, my lord, all I'm saying is this perhaps seems to be an anomaly. My lord, NESL is the authority.
That is all.
Who is appearing in NESL? Yes. Have you taken instruction?
Not taking instruction, my lord, that there are some relevant documents very much necessary, my lord. Only they are saying, my lord, to say, as per the provision of law, they have acted upon. They have nothing to do but to follow.
No, they have acted upon, but subsequently you have informed that the authentication completed on 20th September, and they have acted upon on your form on April 2026. How it can be? You uploaded your authority uploaded the form, they have given the reply, all the proceeding is going on, and all of a sudden you have submitted that it has been on 20th September, it has been completed. It is completed, how the new form has been
and the earlier one was without notice to me. That is also bad.
May I be permitted to submit before a lordship? What time is given to submit the
Yes, tell me how much
opposition, my lord, with relevant documents.
What? My lord, may I suggest this? My lord, as per Rule 53, my lord, NESL is duty bound to complete the authentication immediately.
Correct.
And, my lord, they have to give 4 reminders. Now, my lord, they perhaps don't need more reminders because the client, my lord, is alerted. In fact, they've engaged Mr. Mitra, so they are, my lord, most alerted now.
No, they have given the information. They have continuing with that, but all of a sudden it was stated that it is.
At this, my lord, kindly direct NESL to, my lord, correct this Form D.
On your writ petition. On your writ petition.
No, my lord, because they are challenging.
That's why let he come. Whether
often,
this is with
my lord,
regard to this proceeding
public money is involved. My lord, all I'm saying is this. Often, my lord, for example, in the KMC cases, my lord, some order is, my lord, illegal. My lord, the High Court perhaps sets it aside, but then directs the KMC to within a limited time frame again.
Correct.
So
that's
same
why you are
thing
asking for the NESL. You are telling that simple way, but the NESL is not so simple.
If they now file an affidavit, my lord, this matter will linger for another, perhaps I don't know how long.
And, my lord, documents actually for the proper education of the health.
Either you take instruction whether it is correct. If it is not correct, you are withdrawing this, then you proceed with the new form.
Publish a new Form D in 7 days. And
State Bank is
okay. The Learned Counsel appearing for the NESL prays for time to file affidavit by disclosing certain documents. Accordingly, the NESL directed to file affidavit in opposition by 2 weeks. By 2 weeks, 3 weeks after serving the copy to the Learned Counsel for the petitioner, the petitioner is liberty to to file affidavit in reply within 2 weeks thereafter. Full stop. Let the matter appear. Let the matter appear on 12th August 2026 under the same heading. Interim order is extended till the next date of hearing.
My lord, may I only, my lord, pray for one clarification. My lord, the NCLT proceedings are going on parallelly. Mr. Mitra, my lord, has also, my lord, fairly submitted that I can prove my debt otherwise. Your lordship may kindly clarify that your lordship has not made any observations insofar as the marriage.
Kindly see the order.
Kindly let that clarification be, because
See
Order
the order dated 30th June.
yes,
Till the next date of it, impugn record of default from D, page 11, 190 shall not be given effect.
now, my lord,
That's all,
now,
nothing.
my lord, what they will do is they'll, my lord, use this.
I will do.
That's what they're doing, my lord.
Wait, what is that?
Yes, call.
My lord, before that, my lord, takes up number 6. Where Mr. is there.
Have you taken this?
Lord, I have taken instruction. Lord, the instruction is this: as yet they have not contemplated any coercive action against
Why
them.
I am ready with my material.
And my lord, they said that give us fortnight's time. We will come up with the appropriate instruction. We will not take any coercive action.
Very well, your lordship may kindly direct.
So you will file affidavit or take report.
I shall file a report in the form of affidavit.
What report? Only
There is no report, my lord. Kindly keep it after fortnight. I think it will be resolved.
Learned counsel appearing for the state press for 2 weeks time.
Yes, my lord.
Press for 2 weeks time and submit that. In the meantime, the authority will not take any coercive steps against the petitioner. In view of the submission made by the counsel for the petitioner, respondent, the case is adjourned. Let the matter appear on 30th July under the same heading.
In the meantime, they may file a report or whatever.
Yes, yes, will
In the meantime, the authorities are at liberty to file report, if any, after serving the copy to the London counsel for the petition. Next.
But I appear on behalf of the respondent number 4. But I am for the ECL.
No, the item number 6 of today's list was fixed after the that matter.
This one.
Yes.
This is a fixed matter.
Yes, this is a fixed. Now, my lord, here, my lord, we have received. This is that, my lord, your lordship recollects, my lord, that we could not, my lord, submit our bid, my lord, because of some glitch. Gem. Now, my lord, we have received a letter from ECL. I would say, my lord, a very encouraging one for us. At a copy there, where they are proposing for a settlement. It's very good of them.
This is reviewed without prejudice, correct? So we can hear the matter because lordship has already on the last occasion argued that we are suffering because of the everything is finalized. Lordship has directed us not to publish, so we are not publishing. But now the stock is piling, and there are excess coal in stock now, and there is always a risk of the coal theft. These are problems that we are suffering at the ground.
Kindly have a look to the third paragraph. I do not
because
know
of that, the offer was.
this seems to be incongruous with the letter.
No, letter refers to that problem.
Without prejudice to the rights and contentions of the either party in the pending proceeding, ECL requests your organization to consider whether an amicable resolution of the dispute is possible, so that the tender process may proceed without further delay. If your organization is willing to explore such a course, ECL shall be prepared to engage in discussions in accordance with law. Then, they keep their right reserve. There's nothing wrong in that. So, I was suggesting that in view of this letter, my client will give an officially a proposal on Monday. Let them consider it and come back on Wednesday or Thursday, whichever day they want.
But my instruction is that the paragraph above that paragraph, Lord, the interim order directing maintenance of status quo has, however, resulted in delay in finalization of the subject procurement, which is connected with the operational activities of the company. Any prolonged delay in finalization of the tender may adversely impact the operational requirements of ECL and consequently the larger public interest served by.
So what I propose to do in terms of that, let the petition submit tomorrow. Tomorrow is close.
They can come. No, tomorrow we are not closed. They can approach tomorrow.
Made a representative by tomorrow and take a decision by Tuesday, and I am fixing on Wednesday.
But because my instruction is to
correct. I am considering your second paragraph. There is an urgency. So in terms of this, let them make a representation tomorrow, and you consider Monday and Tuesday. Come on Wednesday here. Take a decision whether it is not. If it is not, then I am.
Then we'll proceed with the matter.
Lordship,
consider that. Yes.
Lordship will yes, will very well. This is without prejudice. Lordship kindly record.
Oh yes, definitely.
Lordship kindly record that.
Without prejudice to both the parties.
Learned counsel for the petition handed over the communication dated 8th of July 2026 issued by the ECL to the petitioner, wherein it is mentioned that, wherein it is recorded that The Land Council for the petitioner submit that in terms of the said communication dated 8 July 2026, the petitioner will make appropriate representation to the ECL by tomorrow. That is kya date hai kal? By 11th of July 2026.
So I have been instructed, subject to your lordship's permission, to allow us to give it latest by Monday. We'll try to give it by Saturday. Kindly permit us to give it latest by Monday, because
I want to come back on Wednesday.
On or before 13th of July 2026, and if any representation is received by the ECL, the same may be considered by on or before 15th of July 2026.
By 14th, let me come back on 15th, on Thursday,
14th of
Wednesday.
July 2026, and let the matter appear on 15th July for submitting report by the ECL with regard to the representation, if any, submitted by the petitioner.
Grateful.
The model continue on the next day till the
Right.
next day.
But lordship, kindly, if lordship pleases to fix a time like it is fixed today, my lord.
Within not within 5 minutes.
Grateful, grateful.
Instruction. Yes, next.
Item number 25, my lord, I am for the respondent bank, my lord. This matter is coming after a long time without serving any prior
Lordship, I am on behalf of the petitioner, Lordship, item number 25.
Yes.
Lordship, the brief fact was that, Lordship, the loan amount of rupees 9,38,000 have been sanctioned, and Lordship, in my account, only 7,28,000 were credited. So 2 lakhs rupees were not credited in my account. Lordship, after filing the writ petition, the remaining 2 lakhs amount have been credited in my account. So first problem has been solved, Lordship. Now, Lordship, my humble submission before your Lordship is that, Lordship, kindly give a direction for the for my damages, and kindly give a direction for interest only. But the main problem, amount of rupees 2 lakhs, this amount have been credited in my account. This amount has been credited in my account. But after filing the writ petition, after passing the order of your Lordship.
This is my affidavit, my lord. Affidavit. They have not filed any exception to this, my lord. Let the copy of the affidavit be kept on the record. What happened, my lord? He had loan in other banks also. Before granting this, before sanctioning this loan, there was an agreement or understanding that he would close that loans, all those loans, and we'll give him a loan of rupees 9 lakh odd. It is a personal loan, like a nature of personal loan. The nature of the loan is personal loan because he is a serviceman. So that loan will be given 9 lakh odd. But he did not close that loan accounts. So we could only
Which
give
loan account?
Other loan account in other banks, other financial institutions, Cholamandalam. I have the copy. My lord, it has come suddenly today after a long time. So, my lord, I am having it with my mail, my lord. I can produce that to my lord, to show my lord that in the month of May, he has closed the loan account, which was in other bank. And as soon as he closed that loan account, 2 lakh was disbursed. Now it has been disbursed, my lord, and he has accepted that. And this affidavit, he has not used any exception to this affidavit also, my lord.
Yes. But kindly come to a prayer portion. Only prayer is with regard to the disbursement of the 2 lakhs. Now 2 lakhs has been disbursed. With
Yes,
regard
Lordship, 2 lakhs have been disbursed. So, Lordship, the main problem has been solved.
If any further cause of action, you go and challenge. You further
But Lordship, subject to Lordship's
prayer portion.
Lordship, definitely, Lordship. Lordship, subject to Lordship's correction, I want to make one submission in humble form before your Lordship is that, Lordship, kindly come to prayer age. Pass such further and or other order and or orders as your Lordship may deem fit and proper. By making this prayer, Lordship, the ambit of the prayer is very, very wide.
Okay.
Subject to Lordship's correction, I am making this a submission.
Got an order.
But it is a fact that amount of rupees 2 lakhs have been credited in my account, Lordship.
Application praying for a direction upon the respondent number 125 for disbursing the remaining 2 lakhs in the bank account of the petitioner. That the petitioner has obtained a loan of rupees 9,28,000 from the State Bank of which was sanctioned in favor of the petitioner under the scheme of SBI personal loan. by 49272753 full stop. Full stop. After the sanction of the said loan amount, the respondent authorities have only disbursed an amount of rupees 7,28,000 by keeping the balance amount of rupees 2 lakhs. And the same was not disbursed in the loan account of the petitioner. Accordingly, the petitioner has made several requests to authorities, but the bank has not considered the same, and the petitioner has filed the present writ application. Now the petitioner submit that after filing of the writ application, the bank has disbursed the said amount of rupees 2 lakhs in the account of the petitioner on when?
He has disbursed his loan
On
in the month of
26th
May,
of
my
March, 26th, when it was disbursed 2 lakh, 26 March.
No.
When it was disbursed? On 26th of March, 2026. 2026. Full stop. Full stop. He further submit that when the loan was sanctioned?
Loan was sanctioned, my lord.
Though the loan was sanctioned, on 18th of March 2025, but the bank has only disbursed an amount of
Lordship, 18th March 2025.
March 25, but the bank has only disbursed an amount of rupees 7 lakh by keeping the same by keeping the balance amount of rupees 2 lakhs, and as such, the petitioner has suffered damages, and he prays for an order for directing the bank to pay the damages to the petitioner for not disbursing the further loan amount to the petitioner, due to the which the petitioner could not utilize the loan. Okay. Land Council appearing for the bank has filed the report after serving the copy to the London Council for the petitioner. The London Council for the bank submit that the petitioner had earlier loan of rupees home loan.
My lord, express, my lord. This
Lordship, personal loan, Lordship, personal loan.
In other banks.
Earlier loan with other bank, and when the petitioner bank came to know that with regard to the earlier loan obtained by the petitioner from the other bank, accordingly the bank has kept the amount of rupees, has not disbursed the balance loan amount of rupees 2 lakhs, and subsequently the petitioner, after filing of the present writ application, cleared the loan amount of the other bank, has informed to the State Bank of India, and immediately the bank has released the said amount. Full stop. He further submit that as the bank has already released the said amount of rupees 2 lakhs and nothing remains in the present writ application, the writ application is to be dismissed. At the Learned Council for the respective parties peruse the materials on record and the report filed by the bank. The main grievance of the petition in the writ application that the bank has not disbursed the balance loan amount of 2 lakhs, and filed the writ and prayed for a direction for release of the and disbursement of the said loan amount of 2 lakhs. Dependency of the writ application, the bank has disbursed the loan amount in the account of the petitioner, and the petitioner admitted that the same has been released. It is a specific case of the bank in the report that the petitioner has earlier obtained personal loan from other bank, and that was not cleared. And when the petitioner cleared the said loan account and informed the bank that he has cleared the said loan amount, immediately the bank has released the said loan amount under such loan amount. Considering the above, this court find that as the petitioner has received the further loan amount of 2 lakhs, under such the grievance of the petitioner has fulfilled. As regard the damage, this court did not find any circumstances to pass any order for grant of damage to the petitioner. Accordingly, the petition is disposed. Next.
I have a preliminary objection, though I have not been stopped with notice when it was mentioned. Every time that it happens. But I have a preliminary objection when kindly look to the look to the jural part once, jural part of the writ petition once.
I am for the
But this is
Well, let me make my submission. Well, let me make my submission, my lord. Madam, your lordship, for this petition, you also heard this matter on 2 occasions or 3 occasions. Now, my lord, 25th March, your lordship passed an order because I have shown to your lordship the provisions of the act. Because I have been appointed permanently in respect of the my lord Kakdi police station. Subsequently, I have been transferred to the Dola police stations. And the license has been given in respect of the entire area of the Dola police station. Now, the private respondent, without taking any recourse of law, was given the appointment, curtailing my area.
Initially, in which police station you have been appointed? Under which police?
Dola police station.
You have been appointed in Dolhat.
Hello?
Not with the Kakdeep.
Kakdeep, I was appointed initially.
Correct.
Subsequently, I was transferred.
Correct.
No, in Dola police station.
Correct.
And the license was given in respect of the entire area of the Dola police station. I have annexed this license. Now, the private respondent, he was given appointment, deals the statute, deals these rules, and my lord, without proceeding, following any procedure. That's what I have shown the act. My lord, kindly see this act. Kindly see this act. Now, I have given the act earlier occasion. Let me make my submission. You have a time to make the submission. Why are you interfering?
Either you both go outside and fight it and come.
But this is my turn.
If you want, I will engage the Eden Garden. You go the free ground and fight it. You want that Eden Garden to be booked? You're making a submission. Make the submission here.
Is it okay with me?
Maybe. See, it is the advocates. Advocates every time they pinch us so that you can get the high pressure and lose your temper, so that you can lose your case also.
Now, my lord, in respect of the Dhola police station, the private respondent was also appointment. Now, kindly see.
What is the case, sir? You have been appointed initially in Dolar.
I have been appointed initially as
Kakdeep. Correct.
Permanent.
Kakdeep, you have been appointed. Subsequently, you have prayed for transfer to the Dolhad. You have been transferred to the Dolhad.
My lord.
Correct. Now you are working in the Dolhad. So now what is the problem?
Now, problem is that without adopting any rules, without following the procedures, private respondents have been given appointment in respect of that police station.
Which police station? Dolhad.
Dola. Curtailing my area, where the license, I am the permanent MMR in respect of that police station, and where the license has been given in respect of the entire area of the Dola police stations. Now, the private respondent, kindly in respect of that Dola police station, section 3, kindly see, my lord. If any, kindly, section 3.
Yes.
It shall be the lawful for the state of government to grant a license to any person being a Mohammedan, authorizing him to register Mohammedan marriage and divorces which have been effected within the certain specified limits, or application being made to him for such registration, and in like manner it shall be lawful for the state government to revoke or suspend license. Next, proviso. Provided that no more or 2% shall be licensed to exercise the said function within the same limits, and provided further that when 2 persons are so licensed to act within the same limit, the one shall be a member of the Sunni and other of the Shia. I am the Sunni. I have been appointed in respect of the Roland police stations. Now, the private respondent, he is also Sunni. He has been given appointment in respect of the Rola police station curtailing my area. This is the first point. Now, the second point is that kindly see the rules. When I have given the rules on the earlier occasion.
Yes.
Now kindly see 3A. This is the rule 3A relating to the permanent appointment. Rule 3A.
Yes.
Related to the permanent appointment. Now what rule 3A provides on the occurrence of a vacancy in the post of a Mohammadan Registrar or on the creation of a new office in any district other than the district of Calcutta, the registrar shall at once make a temporary appointment to carry out the work of the office, intimate the vacancy to the Inspector General of Registration and invite application for the permanent post. Application may also be received by the Inspector General of Registration, but on receipt he should forward them to the Registrar of the district concerned. The Registrar will send to the Inspector General of
This is
Registration.
a procedure.
This is a procedure for permanent appointment.
Correct.
Now kindly see 3B. This is the temporary appointment. Now he has been appointed temporarily. Now kindly see, in making the temporary appointments, the permanent committee need not consult it. The district registrar shall nominate a person for each vacancy. The district registrar's nomination shall be submitted to the government by the Inspector General of Registration, who, if he disapproves the district registrar's nominee, may recommend the appointment of any other candidates. A temporary license shall then be issued to the candidates approved by the local government. Therefore, here, without procedure, adopting this procedure, straightway the license has been given to him. Without adopting a procedure. Now, first, I have been appointed in a permanent post. Therefore, you cannot make any entry permanently, temporarily in my post. First point. The second point, entire area has been given in respect of my lord, in favor of myself. The license was also in respect of the area of the Dola police stations. Now, the authority, what he has done, without procedure, certainly started my area and allotted him for giving a temporary appointment. And though no Muslim community in respect of that area made any allegation that they are suffering for one MMR. They did not come any complaint. And thirdly, my lord, when the Calcutta Gazette notification has been issued in respect of a permanent appointment, in case of my Gazette notification has been given, I have been appointed on Gazette notification. Now, how a permanent appointee can make entry into a permanent appointment, a temporary appointee? Entire derogation of the rules. This is my submission, my lord.
Okay. Yes.
Editorial limits.
Yes. Jurisdiction. Yes. You are appearing for? Yes.
Shall coincide with the limits, the district, under or within the jurisdiction of one or more goods or parts thereof, as the government may from transferring direct. The headquarters shall even a police station area can be divided into parts.
Correct. No problem.
Just now I have a part of record. Just now I have that 25, this order was issued by the government considering the density of the area. Proposal was made. Ultimately, the order that has been issued part of state or not.
Yes.
So the density was the considered. So ultimately, convenience of the
No, density is the but the act says something else.
Act says,
And they come to the act.
yes.
Provided that no more than 2 persons. So 2 persons can be. Shall be licensed to exercise the function within the same limit, and provided further when 2 persons are so licensed to act within the same limit, one shall be a member of Sunni and other be a Shia.
Same limit has not been given. The rules.
Correct. There is no dispute.
Jurisdiction.
There is no dispute. But how you can be given how?
They have created 2 different limits. In one limit, this is the order. They are given the supplementary limit and the supplementary limit. Does not signature. Not connection of the supplementary.
Page 5.
Yes. By virtue of the authority conferred by the 3
Yes.
of the Act, the
Yes.
governor is pleased to authorize in a manner prescribed by the above Act, which shall be effected within 12 RPS area, this is the limit, comprising territorial limit over parts of Uttarapur 1 and Santo block of 12 RPS. Now, can you see on page 59 of the description? This is my area. And then his name is page 59 of the description. The same language, right?
Yes.
Can you see on this? This is the relevant part. Governor says power shall be effected in Kolahas piece area in the middle. Fourth line.
Is the petitioner.
This is for the petitioner.
These are private respondent. P7, the supplementary private respondent.
And 59 is the petitioner.
Yes.
Shall be effected within the Kolahas SMPS, comprising territorial limits over parts of Convict and Procedural. But 4 blocks has been divided in 2 parts, 2 territorial. For 2, he has been appointed, and for the rest 2, I have been appointed.
But in respect of one police station. No, good morning.
Because this is not a case that within one limit or should need to have been appointed.
Correct.
The orders have been issued in terms of the Act and the rule vendors.
Correct.
This is one part. Second is that absolutely technical, but since we are before the reach for, I take up the jugal part once and paragraph 2 of the jugal part is 14 of the repetition. Paragraph 1 and 2 are to my knowledge.
Yes.
And 3 to 20 are records. Now, these state has been made out in back of footing. Based on no records. So the entire pleadings remains unaccounted.
Yes.
My humble submission would be to dismiss this repetition out. This is not an employment that nobody's salary. It is for the convenience of the people that the government decides to appoint, considering the density of the area. It is not an employee, public employment. But and what there are examples that I can hand over that in different PS. I have obtained all this through RTI. In Badriam, 3 MMR has been engaged by the state. And there are areas where I do matter where depending on the density, government appoints a number of MMR of the same community.
But what would be the effect of the section 3 proviso?
The section 3 proviso is kindly read on second class.
Yes.
Proviso provided that no more than 2%
Correct.
shall be licensed to exercise the function within the same limit.
Correct.
And limit has been prescribed
Correct.
by the authority, by the governor order, and has been segregated separately depending on the density of the function. So this is not a case with the same limit to what is.
Yes, madam. What is your case? Hmm. 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 Yes.
Now, my lord, section 3 provides within the same limits in respect of that particular police station. But limits means, my lord, though the bifurcation, police station has been bifurcated, certain limit has been given to them, certain limit has been given to me, but under the same police station. If that be so, you have been licensed, I have been licensed. But there must be a two separate sector. One must be Sunni, one must be Shia. Because this is under one police.
That is the argument. That then any further reply?
No, no. And second, my lord, rule, in which rule he have been given appointment? Because rule 3B I have shown to your lordship, there must be a recommendation by the district registrar that will be sent to the IGR. IGR, if he disapproves, then he will send another person for the purpose of approval. But here, statewide license has been given. Neither 3A nor 3B has been followed.
Okay.
You cannot give statewide license to a particular person who has not been recommended by the district registers. How a statewide you can give the license to a particular person? The rules have to be followed. This is a specific rule.
Okay.
That has to be followed. But that has not been followed. My specific case is that.
Yes, madam. Which rule they have been appointed? Which rule? Take the report. Which rule? Permanent or temporary? Temporary, then what is the procedure you adopted?
Be a permanent appointment.
Correct.
But thereafter, permanent appointment.
Carry out the office, work of the office. Temporary. Whenever permanent appointment occurs, that permanent appointment is made.
I have given the reply to that. I am giving. I have been given permanent appointment in respect of that post.
Okay.
1 minute. Rule 3A provides.
The petitioner has filed the present writ application. Give a report. Give a report. I filed the present writ application challenging the appointment of the private respondent. Appointment of the private respondent as MMR. As MMR. Yes. MMR on 15th of December 2025. No. Where is the private respondent appointment order? Cannot disclose.
No, the in supplementary with my lord, page 5, I have given that.
On 15th December 2025. Within Dolhat PS area comprising the territorial limits over part of Mathurapur 1 and Parthaprithama CD block of Dolhat PS area in the district of 24 South Parganas. Concept for the petitioner submit that. Where is the report?
Yes, madam.
Submit that. The petitioner was initially appointed as a member for Kagdip PS by notification dated 12th of September 2007. In the year 2009, as per the request of the petitioner, the petitioner was transferred to Dolhat PS from Kagdip PS. The contention of petitioner that the petitioner is working as MMR in the Dolhat PS, but in the said area, the respondent authorities appointed the private respondent as MMR in violation of Section 3 and Rule 3A and 3B. Section 3 of the Bengal Mohammadan Marriage and Divorce Registration Act, as well as Section Rule 3A and 3B of the Judicial Department Registration Notification dated 14th of August 1929. He submits that as per Section 3 proviso, no more than 2 persons shall be licensed to exercise the said function within the same limit and provided further that, when 2 persons are so licensed to act within the same limits, one shall be member of the Sunni and other of the Shia. But in the present case, the petitioner is already working in Dolhat police station as Sunni, and the respondents have appointed the private respondent under the same police jurisdiction, who is also a Sunni. He further submits by referring Rule 3 small a of the rules. Submit that Rule 3 provides for selection of the candidate for Mohammadan of registration in the district other than the Kolkata, and the same is for the permanent post. And 3B is for the temporary appointment. He submitted respondents' authorities by appointing the private respondents have also not followed either Rule 3A or 3B. Full stop. Per contra, this is the submission. Full stop. Per contra.
And another submission, my lord. Since I have been permanently appointed in respect of
Yes.
Rule 3A,
It is further case of the petitioner that the petitioner is appointed in the Dolhat PS as permanently, and as such the appointment of the private respondent is illegal and violation of Section 3 and the rule thereto. Per contra, an advocate appearing from the private respondent submits that the petitioner was appointed in Dolhat police station. Subsequently, the government has taken a decision for segregating the part of Dolhat police station, taking into consideration the density of the population of the said area. And accordingly, it is found that, it has been created 2 parts. One part with Kagdeep and Kulpi of Dolhat police station, wherein the petitioner was appointed, and another part is
only in the supplementary affidavit.
another part is Mathurapur 1 and Partha Pratima CD block of Dolhat PS. After segregating the Dolhat police station in 4 parts, the petitioner has been given the work of MMR in the at Kagdeep, Kulpi and Kagdeep and Kulfi of Dolhat PS, and the private respondent was appointed in the Mathurapur 1 and Parthapritam CD block of Dolhat PS. By full stop. He submit that Section 3 proviso provided that no more than 2 persons shall be licensed to exercise the said function within the same limits, and accordingly the private respondent was not appointed under the limit where the petitioner is working. The working area of both the petitioner and the private respondents are different. He further submit that He further submit that under Rule 3 Rule 3 small a of the rule provide that on occurrence of vacancy in the post of Mohammadan Registrar or in creation of the new office in any district other than the district of Calcutta, the registrar shall at once make a temporary appointment to carry on the work of the office, intimate the vacancy to the Inspector General and invite application. Under such, the petitioner was appointed, the private respondent was appointed on temporary basis till the permanent post is filled up in the said area. Learned counsel appearing for the state has submitted the report and submits that and has adopted the submission made by the counsel for the private respondent and submit that the submission made by the counsel for the private respondent has been followed by the state authority while appointing the private respondent on temporary basis. Had the learned counsel for the respective parties peruse the materials on record. Admittedly, the petitioner was initially appointed in the Kagdip area, Kagdip PS, and as per the request of the petitioner was transferred to Dolhat PS from Kagdip. The respondents find that the Dolhat PS, the Muslim population density in the Dolhat PS is high, and accordingly the authorities have taken a decision that the Dolhat PS is to be segregated in 4 parts. The authorities have segregated the Dolhat PS in 4 parts, that is Kagdip and Kulpi, and Mathrapur 1 and Partha Pritama portion. Accordingly, taking into high population density of the Muslim in this set PS, the petitioner has been given the work of MMR in the Kagdip and Kulpi, and the private respondent has been given the work of MMR in Mathrapur 1 and the Partha Pritama portion. Considering the full stop, Section 3 of the Act of 1876 reads as follows. The proviso of the said Act says that no more than 2 persons shall be licensed to exercise the said function within the same limit. In the present case, though the Dolhat police station is the one, but taking the consideration of the high population density of the Muslim population in this PS, the authorities have segregated the said PS in 4 parts. And accordingly, the petitioner has given the work of MMR in 2 parts, and the private respondent has been given in the 2 parts. Considering the same, this court finds that the authorities have not violated the provisions of Section 3 of the Act of 1876 as alleged by the petitioner. As regards the violation of Rule 3A and 3B while appointing the private respondent, this court finds that Section 3B is concerned, 3A and 3B reads as follows. In the present case, the respondents have appointed the private respondent on temporary basis. Clause 3 within bracket Rule 3 within bracket A provides that on the occurrence of a vacancy in the post of Mohammadan Registrar or on the creation of a new office in any district other than the district of Calcutta, the registrar shall at once make a temporary appointment to carry on the work of the office.
No, only one. Before filling up the permanent vacancy, temporary appointment. Here, temporary vacancy, permanent vacancy filled up.
In the present case, it is found that though initially the Dolhad police station, the total Dolhad police station work has been given to the petitioner to work as a MMR. Subsequently, by taking into consideration of the high density population of the Muslim in the said area, the authorities have segregated the said Dolhad police station in 4 parts. 4 parts, that is in 2 equal parts, in 4 parts. The petitioner has been given 2 parts and the private respondent has been given 2 parts. Thus, the private respondent has been given the 2 parts on the temporary basis, and it is admitted the petitioner, the private respondent has not been appointed on the permanent basis. Considering the above, this court finds that the appointment of the private respondent on temporary private respondent in the part of the Dolhad police is not illegal. Accordingly, this court did not find any merit in the present writ application. Writ petition is dismissed. But I have to take them. Are you? Yes. सर जेरॉक्स लेके रखना. Yes, next.
Lord, I am appearing for the petitioner, Your Lordship, in the item number 27. My Lord, it is that matter, Your Lordship, where the minors passport.
7.
My Lord, 27, Your Lordship. My Lord, the renewal was denied on account of non-disclosure of father's name.
Yes. Yes.
Am I audible, my Lord?
Yes, yes, yes.
Now, my Lord.
Where is the impugn order?
Your Lordship, this was not communicated, my Lord, by a written order. This was verbally communicated. Now, my Lord will find a demand justice of ours at page 29.
Yes.
Kindly comes to page 29, my Lord.
Yes.
Lord, this states the entire fact. What has happened? Lord, the initially, my Lord, first renewal was done in 2019. At that point in time, they did not insist upon the father's name. Now, my Lord, in 2024, when at the time of second renewal, they say, no, father's name is very much required. Now, my Lord, admittedly, the father of this child abandoned the mother and the child when the child was 4 years old. Now, my Lord, this lady who's the petitioner, my Lord, she comes the the lowest strata of the society, Your Lordship. She works in various household as a household help. Now, my Lord, she is lucky that she could get a home where the persons she is working for, they have sponsored the child's education. Now, my Lord, this child is studying, Your Lordship. Now she wants to go abroad for pursuing higher education. Now, my Lord, so far the law is concerned, my Lord, I would like to place a judgment which deals with a similar issue, Your Lordship.
So what is the instruction?
I could not hear, my Lord, learned history, my Lord.
Yes.
So, my Lord, my land reference clients wants, my Lord, the passport only by giving the name of her mother without disclosing the name of the father. Now, my Lord, whether it is permissible. Kindly have a look, my Lord, just see the pleadings. My Lord, kindly turns. Kindly comes to page 3 of the writ petition, paragraph 5. Rather, may I place paragraph from paragraph 4 onwards?
Yes.
Paragraph 4 says, a petitioner states that she got married once Bapi Gollar in the year 2005, and out of the wedlock, they were blessed as and such. Now, subsequently, certain dispute arose between petitioner and the said Bapi Gollar, and they started living separately on and from the year 2016. The petitioner submits that she has raised her daughter as a single parent in all these years. The said Bapi Gollor, being the biological father of the minor child, has never taken any endeavor to ascertain the whereabouts and well-being of the child, and has completely abdicated his duty and responsibility towards the child. Now, so far as this Bapi Gollar is concerned, my lord, he has not been implicated as a party to these proceedings. Now, kindly see the writ petition, my lord, page 2. First was Union of India, second regional officer, next, my lord, officer in charge. Now, my lord, so far as this Bapi Gollar is concerned, my lord, is a necessary party. On the last occasion, my lord, in another matter, Tanvi's house matter, your lordship, my lord, directed for implement of the father. And the father came and gave a declaration that I have no objection. That is in respect of, my lord, adopted daughter. So, my lord, my first point is, my lord, there is no divorce as on date. My lord, there is no proceeding has been initiated, even if the person is missing for the last 7 years. My lord, there is a provision in the Evidence Act. And now, my lord, your lordship knows 107, 108 is there. The proceeding has to be initiated, that person is missing. Now, my lord, as on date, there is no proceedings to that effect. Now, the custody of the child is concerned, my lord, so far as custody is concerned, my lord, there is no proceeding also pending regarding custody of the child. Now, in such circumstances, my lord, whether I can issue the passport by giving the name of the father and mother. I have no objection. I can issue immediately. But what they are asking for, only the name of the mother, by deleting the name of the father, which I can't do this. My lord, my rule also prescribed to.
But yes.
My,
What rule you are
yes,
applying?
kindly have a look, my lord, my manual. Kindly see this manual.
Sir is placing 2016 manual.
No, 2020 manual. 2016 manual has been superseded by 2020 manual. And we have provided you most probably, subject to correction. Now, will you kindly see the manual. In manual 4.3, your lordship would find, it says, has your lordship got it, right?
Yes.
4.3. In case of minor children of married parents, the name of the father stroke mother shall be furnished by the other single parent having the custody of the child, irrespective of the status of their marriage, such as divorce pending, separated, deserted, with or without visitation right to the external parent. So, my lord, she can apply for that. There is no doubt. But whenever, my lord, I will be issuing the passport, my lord, I shall have to, my lord, mention the name of the father. I cannot delete the name of the father. How could I, my lord, delete the name of the biological father?
Yes.
And, my lord, and, my lord, so far as, my lord, initially, in the 2016, my lord, there is a provision. In the 2016 manual, my lord, what my line friend is saying, initially the passport was issued by giving the name of the mother only. In 2016 manual provides for that. But 2020 manual, my lord, does not provide for that.
Where is 2016 you are having?
26, 29.
2016?
Yes. 2016 manual. Well, this is the 2016 manual. Can you see in the second paragraph, following policies changes have been made inter alia on the basis of the recommendation of this committee. The online application form now requires the applicant to provide the name of the father or mother or legal guardian, the only one parent, not both. This would enable the single parents to apply the passports for their children and also to issue passport where the name of either the father or mother is not required to be printed at the request of the applicant. So, this was the policy, which was prevailing at the relevant point of time. That's why, the passport was issued in the name of the mother, not mentioning the name of the father. But now, in view of the latest 2020 manual, it cannot be issued. I cannot wipe out the name of the biological father. And more so, the biological father is not before your lordship also.
My lord, may I submit?
So far as judgment,
My lord, may I submit, my lord?
So far as, my lord, judgment relied upon by my learned friend, my lord, on the last occasion, my lord, my learned friend has relied upon, my lord, two judgments. My lord, if your lordship, my lord, kindly takes, my lord, the first judgment, that is, my lord, the judgment
My
of...
lord, before my learned senior argues on the judgment, since I have been just appointed, I am not placing reliance on those two judgments. I'll be placing reliance on one Delhi High Court judgment, your lordship. One Delhi High Court judgment.
And, my lord, if your lordship, my lord, kindly takes the Passport Act also, my lord, kindly see, my lord, what is the position of law regarding this. My lord, kindly see this Passport Act. Now, my lord, your lordship, my lord, state way. kindly comes, my lord, page 51 of this book. My page will be telling, my lord, that's why I'm.
Passport Act?
Yes. This is, my lord, page 51 in lawsuit, my lord. This is, my lord, section 4, documents to be attached with the application.
Yes.
Now, my lord, next, my lord, you will also find. Kindly turn, my lord, page 58.
Yes.
Page 58, my lord, you will also find Annexure C. It says, my lord, affidavit to be submitted with the applications for a passport of a minor child by either parent who are separated but not formally divorced, or by a single parent or the child born out of wedlock to be executed on non-judicial stamp paper. Well, these are in this form, my lord, it says, well, the name of the single parent shall be declared as follows. They are the mother, father, who is a minor of such and such with a minor child, and on whose behalf I have made then applications for his or her passport. I am judicially separated from the mother or father, minor name of the minor. That I have no legally valid marriage ever subsisting between such and such and such. Well, in this form,
divorce.
yes. Now, my lord, kindly have a look, my lord. Page in this book, my lord, page 51 once again. So, my lord, your lordship statement comes to page 108 of this book.
Yes.
Now, your lordship find
9, clause 9.
yes, clause 9. Parents are separated but not divorced. Now, my lord, kindly turn, my lord, clause 11. Applied by one parent, guardian, when consent of one or both parents not possible. Well, what are the documents required?
Parents are not separated but not divorced.
Yes.
Parents with whom the child is residing,
And
if any with the spouse name and goes. Yes. Then
and applied by one parent, stroke guardian, when consent of one or both parents not possible. Now, your lordship, my lord, second column, your lordship,
where from you are reading?
my lord, page 108. Page 108, my lord, serial case number 11.
11. Applied. Applied with one parents. When consent of the or both parents not possible.
Not possible. Now, you will also find what are the documents required. Number 1 of parent, serial number 1, 2, and 27. Now, my lord, these documents you will also will kindly turn, my lord, page 111.
111.
11. Page 111, my lord, you will also find the overall list of documents.
Yes.
Last, table 3.
Yes.
Number 1, proof of present address. That is, my lord, these are the documents, any of the documents will have. Number 2, my lord, 2. The proof of date of birth, attach any one of the following documents. No issue. Now, my lord, kindly turn, my lord, next.
27.
27.
Attested photocopy of
Attested photocopy of passport of both or either parent. Now, my lord, this is the fact. This is the situation. My lord, so far as this case is concerned, my lord, I have no objection to give passport. Name of, I have no objection to issue passport, my lord. But so far as naming of biological father, I cannot delete the name of biological father.
Yes.
My lord,
May I submit, your lordship? May I submit?
Yes, where is
Lord,
the
so much. My lord, lordship, my lord.
where is your application for grant of passport?
My lord, page 27.
My lord, will find
Page
my
27.
application at page 27.
Yes.
Lord, kindly sees that this application form itself allows a single parent to apply. Kindly comes to the column of family details. Kindly sees, my lord.
They are not telling that the both parents should be applied. They are telling the one parent, but why you are not mentioning the name?
My lord, may I submit one thing with kind permission from my learned counsel? Actually, fact is, my lord, the lady who is writ petitioner before your lordship is a domestic helper working with under some family, my lord.
Correct.
And the person who is the biological father of this child giving abandon that wife, and there is no whereabouts.
Correct.
If your lordship directed me, only the name is required, I will definitely do it, my lord. But the police authority.
In fact, Lord, at the time of obtaining My lord, may I just indicate, my lord, at the time of issuing the first passport, your lordship, the father's name was given. My lord, my difficulty is, may I just indicate, my lord, my difficulty is today, my lord, I cannot make him a party to this proceeding because I do not know where he is. Number one. Number two is, your lordship, my lord, this problem I will face at the time of police verification when police will ask me where is the details of the father, because I have no details to provide to them. Lord, this issue, this particular issue with regard to the memorandum that my learned senior, esteemed senior has showed, my lord, came up for consideration before the Honorable Delhi High Court. My lord, that is why I was pressing so much on my lord, showing that judgment. My lord, kindly takes up that judgment for once, your lordship. Kindly takes up. It's 2023 SCC Online Del 2323. Smita Man and another versus Regional Passport Officer. My lord, kindly sees paragraph 9 onwards.
Page.
2323.
Issue was, your lordship, the parents were divorced. It was a settlement agreement. Here the lady knew about the whereabouts of the father. My lord will see, my lord, this particular clause, my lord, 4.3 that has been shown, my lord. Kindly see paragraph 16, your lordship, the submission, and thereafter the view of the court.
Yes.
So, my lord has seen paragraph 16, your lordship. The issue was as to what would constitute as a single parent or unwed parents. Unwed, I am not coming into. A clarification was sought for. That is in paragraph 17. My lord has got that paragraph, my lord.
What you given?
Sorry, my lord,
Where is the complete judgment?
Yes, there it is. পেজটা খুলে গেছে।
And I apologize, my lord, on their behalf, my lord.
Yes.
My lord, now kindly sees paragraph 17. My lord, a clarification has been sought for. May I just read it out? The OM dated 28th February 2022 relied upon the respondent, that is the passport authority, that says,
No,
Lord,
here
the second,
Madam,
the
here
second,
28th February, where is the 28th February memorandum?
Yes.
28th February
my lord,
2022.
this 28th February, my lord, was a clarification which was sought for during the matter was going. My lord, in this particular case, my lord, if my lord kindly sees paragraph 16, here the memorandum my learned esteemed senior has shown, your lordship, that has been considered. My learned esteemed senior has placed clause 4.3. Lord, here clause 4.1 and 4.3 both have been considered. May I just read it out, Your Lordship?
Madam,
It is in internal
28 February 2022 OM, which the court has considered.
Lord. This OM, Your Lordship, is not with us, Your Lordship.
Then you are taking the one judgment and coming without the memorandum. What is the contents of the memorandum? Here they are relying upon the 20, and 20 has been described in paragraph 16. Thereafter, the court has gone to the 2022. You are not relying upon the 2020. Where is the 2022?
My lord, this particular, my lord, this particular, Your Lordship, memorandum was with regard to Patiala House, my lord. In that, my lord, Passport Authority, they have issued this memorandum, Your Lordship.
Right.
That is the Patiala House.
My lord, the court's view starts at paragraph 18. My lord, kindly cease once.
That's why the court has totally taken into consideration of the OM 28, 2022.
But my lord, the court's view is not limited to the OM. And my lord, the court has laid down, my lord, the conditions where, my lord.
Then it's very difficult. The Land Council for the petitioner has relied upon the statement asked by the Delhi High Court in the case of Smita Man and another versus Regional Passport Officer reported in 2023 SEC Online Delhi 2323, wherein the Delhi High Court has considered.
My lord, kindly, my lord, may I interrupt? My lord, kindly sees once paragraph 23, my lord. That much. Paragraph 23, my lord.
Kindly, my lord.
Internal page 13, my lord.
Consider the OM dated 28th of February 2022. But in the present case, neither the respondent nor the petitioner have placed the OM dated the above mentioned OA. Accordingly, respondents are directed to produce the OM, the above mentioned OM on the next date 6. This is the matter on 23rd July 2020.
But before that, Your Lordship, I am requesting Your Lordship, kindly go through this letter once.
Yes.
Lord, kindly see, Lord, on how many occasions, Lord, they took adjournment, Lord, this is a letter, Lord, they are writing to engineer.
Why?
My lord, may I submit? Is he allow me to submit before your lordship? My lord, we are acting on behalf of the client, and they are
not about the order passed by this court. This court is taking the matter.
My lord,
This court is not directed and
from the April 2025 they are appearing.
Yes.
On that occasion, they never
So you
paid
could
for
have
a position.
see, madam.
If
You are the writ petition, please hear the court. If you are the writ petition, you are filing a writ application, whatever the documents you are relying upon, first you have come with all the documents. The court cannot ask for the document from the respondent. You are relying upon one judgment. In the judgment, you have read this is the memorandum. What is the duty of the advocate of the petitioner or the party? To search out the memorandum, whether that is fitted in the matter or not.
I'm sorry.
And where is the
I apologize, my lord.
where is the direction of the affidavit?
No direction.
Why this letter has been written?
My lord, is
To the
written
government,
on the-
government advocate. This
My lord,
kind of
I am
practice
requesting him to file opposition, my lord. And they
My
have
lord, I apologize on behalf of them, my lord. They have acted, my lord, out of anxiety, my lord. Kindly, my lord, do not take it otherwise, your lordship. My lord, and so far, my lord, that memorandum, your lordship, my lord has directed the respondent because, my lord, I tried to, my lord, let me be very honest, I tried to search it online, my lord, I could not find it. So if the respondents can produce that document, my lordship.
My lord.
Your Lordship, in this 183, I do not find the appeal document. 183, item number 183. It's a
No,
SIR matter. 182. 152. 152. 152. Sorry.
151. Who is appearing for the 152?
My lord, appeal. Appeal.
Where is the appeal?
This.
They are not annexed with the writ petition. We can't take instructions whether it has actually been filed or not.
Then you will go to the bar and telling that the judge is so aggressive.
Your Lordship. Your Lordship, on last week, this matter was.
I've done some mistake.
May I pray?
Sending the matter, my lord, SIR matter urgent. When the matter is taken up urgent, no appeal in the file.
Your Lordship, may I appraise your Lordship? On last week, this matter was there. The petitioner was directed to file the SIR number, get the SIR number. So he has brought it today separately. This should have been by way of a supplementary affidavit.
Affidavit service filed with the petitioner will be kept in the record. The petitioner has filed the present writ application with the grievance that the petitioner has preferred an appeal before the SIR appellate tribunal, but the same has not been disposed of and paid for expeditious disposal of the appeal.
Lordship, the appeal has not been served upon us till now.
Give the copy.
I asked my learned friend, he doesn't have the copy.
I am not passing any order.
On the next date, it may be passed because he doesn't even have a copy.
Not today. Next.
153 is my application, my lord. Here the individual is still under adjudication, my lord. Last occasion it appeared before your lordship, my lord, and learned advocate for the ECI to take instruction, my lord. The other family members of the individual has been included in the voter list.
Have you taken instruction,
Your
madam?
Lordship, these are cases where the judicial officer in the second stage of SIR, they had by mistake forgot to digital sign the documents. There are certain similar cases which are pending for, as shown as on the website as adjudication. We are working on it. Give us another 1 month's time to resolve this.
1 month time.
I could not vote
Your Lordship,
the assembly election also. I am a voter for last 35 years.
Okay, let it 4 weeks. As per the prayer made by the council for the ECI, case is adjourned. Let the matter appear on 7th August.
Only one, just let them direct to come with a compliance.
Yeah, that's
no, I'll provide. I'll share it with my learned friend. Your Lordship, item 154, relevant page is page 30.
Under the SIR.
I am for the petitioner, my lord. Page 30, my lord. Page 30, appeal, my lord.
30. Single petitioner.
I am for the
Sole petitioner.
Yes, ma'am.
Format আছে, format আছে. Affidavit service filed, huh? Next. Preferably 3 months.
Page 49, relevant page.
Item number?
My lordship,
155.
How many petitioners?
2 petitioners, my lordship.
How many?
2 petitioners, my lordship.
Next.
I am for the petitioner, my lord. 1 petitioner, my lord.
Page 20, Your Lordship.
Yes, Dispose of. 157. Who is appearing?
My lordship, I am for the petitioner.
Where is the form? Where is the appeal? Yes, dispose of. Next.
But I'm for the petitioner, my lord. 3 petitioner before my lord. In respect of petition number 3, my lord, already my lord, his name has been included in the, after filing the writ petition, my lord, his name has been included in the electoral roll, my lord.
Note current 150.
158, my lord.
158. Though the 3 petitioners have filed the present writ application, but the land counsel for the petition submitted during the pendency of the present writ application, the appellate authority have already decided the appeal of the petition number
3, my lord.
3, namely
Shoaib Mohammadan.
Accordingly, the
My appeal is, my lord, page
appellate
64,
tribunal is directed to
69, 67 and 69.
The petition number 1 and 2, and to pass and to pass appropriate order and to dispose of the same as early as possible within a period of 3 months. Preferably within a period of 3 months. Yes.
My lord, I am for the 159.
Your lordship, the copy has scanned copy may be provided to us.
Service has been served.
The
my lord.
copy. Why you not serve the copy?
Yes, sir. My lord, I am 159. I already served the copies, my lord. And page number 17, the appeal page number 7, appeal is there in the one page number 17. Okay.
Now you serve the copy.
I have already served the copy, my lord.
To whom?
Your lordship, we require the scanned copy to be handed over to the protocol officers.
Okay.
Give one copy, otherwise the protocol officer will not get the copy, then it will be not listed.
Okay. Obvious, my lord.
Dispose of.
160, I am the petitioner, my lord. And here also, the derivative service has been served.
Dispose of.
And at the page number 15.
Yes.
This is also, I am the petitioner, and the derivative service has been filed.
Dispose of.
Appointment.
I am for the petitioner, my lord. 1 petitioner, my lord. Page 19, my lord.
Page
19, 19.
Yes, dispose of.
I am for the petitioner, my lord. Page 18, my lord. There is also 1, my lord.
Dispose of.
I am for the petitioner, my lord. Page, my lord, 20.
Page
20, 20.
Yes, dispose of.
I am for the petitioner, page 17, my lord. 1 petitioner.
70.
Yes, 17, my lord.
Yes, dispose of.
I am for the petitioner, page 23, my lord.
Yes, disposal.
Page 20, I am for the petitioner.
Disposal.
Page 18, my lord.
Dispose of.
I am for the petitioner, page 19, my lord.
Disposed of.
I am for the petitioner, my lord.
Dispose of.
I am for the petitioner, my lord. Page 20, my lord.
Dispose of. And for the petitioner, my lord. Page 19, my lord. 19. Dispose of. Page 30, my lord. How many you are having? One.
Till 174, I think. 175. Who actually? 175.
Page number? 20, my lord. Huh? 174, my lord. Page 20, 20. 20. 173. No. 173. 173, 30. 130, my lord. Yes, dispose of. Yes. Page 20, my lord. Yes. 25. Here is my lord, two petitioner, my lord. Court fee, another my court fee has deposited. Page 25 and 27. Court fee paid? Yes, my lord. This is highway. Disposed. Disposed of. Yes, sir.
But I'm for the petitioner, my lord. Three petitioners and I have paid the deposit for them. This is the document. My lord, page 68 to 73. 68 to 73.
Disposed of.
177. My lordship, I'm for the petitioners. Page number 20. Yeah.
27.
I'm for the petitioner, my lordship. Page number 19.
Page number?
19.
90.
19. 19. Yes. Small. Madam, mail.
90 is this not online?
Online is 21, my lordship.
No. Page 19, can you see? Item number? 178. Can you see the 90? It is not online. It's the physical appeal.
78.
That's why I am verifying whether it is not online, then it will be difficult. There will be a non-number. Then how the appeal will be heard?
My lordship, this is offline. Page
That's why
number
offline. Where is online?
21, my lordship. Page number 21.
Yes, please. Yes.
My lordship, I'm for the petitioners. Page number 46 is online and page number 49 is offline.
Yes. Disposed of.
My lordship, I'm for the petitioners. Page number 26 is online and page number 31 is offline.
Page number?
26 online, page number 31 offline.
Disposed of.
Your lordship, in this, the writ petition doesn't have the appeal copy.
15 is the appeal copy. Got it?
Your lordship, actually, the soft copy has not been served.
Take. Give the
Soft
copy.
copy ta diye deven na, sir.
You have extra copy? Give.
But
They have to
mail will
contact
be
their
required because
protocol.
it's easier to send. Your lordship, I would only require scanned copy.
No hard
Because
copies.
I need to hand it over to the authorities. I've informed the advocate in record.
Disposed of. Counsel for the appeal submitted during the pendency of the writ application, appellate authority decided the appeal. Accordingly, WPA number 13307 of 2026 is become infectious. Disposed of.
My lord, I am for the petitioner, my lord. My lord, in this matter, my lord, appellate tribunal, my lord, in the status, my lord, it has been shown that my name has been excluded from e-roll, my lord, without giving any opportunity of hearing.
Where is that?
My lord,
where is your appeal?
My appeal is, my lord, my lord, page 39. Page 37 is appeal. And page 39 is the status report. My lord, action taken on 29th March 2023, pending action taken on 9th of June 2026, status excluded from e-roll. Without affording any opportunity, I only pray for my lord reconsideration by the appellate tribunal. Your lordship has also passed the
Your
similar
lordship remitted back to the tribunal.
Petitioner has filed the appeal before the SIR tribunal, before the SIR tribunal on 29th of March 2026. 2026. Subsequently, on 9th of June 2026, it is on in the online. It is recorded as excluded from e-roll. And counsel for the petition submit that without giving an opportunity of hearing to the petitioner, the appellate tribunal has taken up the matter and excluded from the e-roll. In view of the submission made by the counsel for the petitioner, the appellate tribunal is requested to restore the appeal filed by the petitioner, being appeal number APS 2517G29032621062 and to dispose of the same.
Giving an opportunity of hearing if at all.
Dispose of the same as early as possible, preferably within a period of 3 months from the date of the order.
Grateful.
Next.
My lord, I am for the petitioner. Page 19 is the copy of the appeal.
19.
19.
Disposed of.
My lord, page 17. Page 17. My lord, page 26.
Disposed of.
My lord, page 25.
Disposed of.
Page 18.
Disposed of.
My lord, page 29.
Disposed of.
Grateful.
Page 19, my lord. One nine.
195
Disposed of.
195
I am for the petition, page 18, my lord, 18.
Disposed of.
Lordship, I am for the petitioners, page number 27.
Your lordship, in some at least 4 months time may be given because 3 months.
Then let it go. We'll see to that.
Lordship, I am for the petitioners,
Where is your appeal?
page number 69,
69.
69 and 73.
2.
Offline and online.
Okay. Disposed of.
Grateful, Lordship.
Disposed of. Disposed of.
Grateful, your lordship.
Would your lordship?
File it and mention.
Would your lordship allow for extension now, or after recess, but I have given notice, or would your lordship mind to keep it on the
At come at 3, I will take.
3?
Or send the junior.
Very good. As a lordship. Grateful.
I am representing on behalf of the state.
Who is for the petition? Mr. Banerjee, you
I
are?
beg to appear on behalf of the petitioner.
I beg to appear for the respondent number 8.
Yes.
That I am told, my lord, yesterday only, my lord, upon the learned advocate on record, my learned GP, government reader, it was served. My lord, I can understand, my lord, my learned friend has not got a copy.
You are appearing for whom?
State.
State. And you are for the respondent number 8.
Right, respondent number 8.
Rejected otherwise. My lord,
You
if my
received a
learned
copy?
friend wants, my lord,
The copy is not available to me. Yesterday, yes, sir.
Who has served?
You
have received?
I did not receive till, but earlier it has been allocated in my favor by the Heir.
my lord, if my learned friend wants a further copy, I will request my learned advocate on record to supply one more copy. And
Though the matter is specifically included at 2 p.m., but the learned counsel for the state submit that he has been assigning the matter, but he has not received the copy of the writ application and other documents. The petition is directed to serve the copy of the writ application and other documents to the learned advocate appearing for the state. Let the matter appear. 10 September at 2 p.m.
Date
For affidavit of service completed.
September.
Yes. Next.
Can it be in August, my lord?
Call the list. Call the list.
Lordship, Mr. Ashok Banerjee is coming just within a second. I will start. This is an allegation relating to the department.
Who is for the state?
Here.
Have you served?
Yes, Lordship, we are just filing the affidavit of.
To whom you have served?
Parties and to the government figure.
Only government paid. Where are the how many parties are here? Respondents. Where is the service? No service. Only one government has been served, government pleader's office. What about the other respondents? See.
Notice দিলেন না কেন?
To whom? Where is the email? Yes.
My lord, one thing is very clear. I've just, as I always do, my lord, kindly have a look to this. Hey, no, judge copy to down. Judge copy down. Judge copy. Kindly take time to look at this, my lord. At a short, I'll try to make it shorter. Now that bid for extraction of the sand, and his bid was accepted by the respondent on June 17. Clause 17 provides that bid validity period 120 days. The completion date fixed to 40 days, that's number 2 for the least works. The petitioner fund is banked to the tune of 87 crores, 87 lakhs 30,000. As per condition of the acceptance of tender on June 2025 with a claimed expiry date August 35, 2026, which has not been expired anyway. The respondent did not provide the copies of the acknowledgement. Is very material, my lord. agreement for execution of the by the respondent. Admittedly, copies of the agreement was handed over to the petitioner November 19, 2025. After expiry of the bid validity period, the respondent suddenly served a so-called notice on May 26, 2026, directing the petitioner to submit a response within 72 hours from the date of time receiving the said so-called notice. Then petitioner furnished reply on May 29 for obvious reason because incidentally May 28, 2026 was declared a public holiday by the government of West Bengal and his date ought to have been excluded from the Act on the General Clause Act. Madam knows better than me. Even after receipt of the response reply from the petitioner to the so-called notice, May 29, 2026, and without holding any hearing, the respondent invoked bank guarantee, Kali marked it, my lord. On the same day, that is on such, and the guaranteed money was remitted by the bank. The petitioner objected to such wrongful and illegal information by the latest. Strange to note, the respondent on the same day replied to the response of the petitioner to the so-called notice, alleging that the so-called notice was served on 13:00 hours on May 23, 2026, whereas the said response was allegedly received on 14:38. The petitioner raised strong objection to the said memo of the respondent dated May 30, 2026 by letter and such, and the request the revocation of the PG and finding no response, the petitioner. Then next page is very interesting. Just pause here for a moment. Naturally, with notice we always have. As soon as we serve the notice, my lord, and we pointed out the matter is going to move before my lord says, oh, please come on, please come on. Immediately the position is changed, Kali read. Now after filing of the writ petition, the respondent invited the petitioner for a discussion by an interrogative. It's the magic. Obviously, you will have to mention the name of the honorable judge because before whom the petition to be moved, suddenly they have changed the stand. On July 3rd,
so you mean to say the respondents have heard the name of the judge?
I can tell you one thing, my lord. Justice Olive my lord knows that my lord for a long period. As soon as notice how we are going to move with the Olive you are so strict and but very otherwise reasonable, Justice Olive and naturally. Before moving this, please come to us. We'll decide everything. They are frightened. They are shaky. Then now, the respondent invited the petitioner for a discussion by later dated such and such. In writing, they invited. The petitioner attended the said meeting, and before commencement of the meeting, the petitioner also clarified his position by later dated such and such. Everything in writing. During the meeting on July 3rd, 2026, petitioner was represented by his authorized representative upon finding a power of attorney, and the attendance of all the attendees were also recorded. During the discussion, the petitioner was advised to furnish his proposal for resuming the work, and the petitioner submitted his proposal on the same day while it is such, wherein the petitioner put 4 months, 4 conditions to resume the work. No response that has been received. So, my lord, admittedly, it shows there is some laches fault on their part. That is why otherwise they have no garage in Bengali, what is called, my lord, to invite me for discussion. They say, very well, you can do the job. Let us say, what is your proposal? We supplied that, no actions. But 3 courses are there. If they say, very well, we want to use an affidavit, I don't mind. And secondly, my lord, by taking this time to file affidavit, they cannot take action against me. Coercive action.
No, what I propose to do, you have given the, as per the meeting, you have given the proposal. Let them give the report what they have taken the response.
I done.
You have your response?
You have informed us?
Yes, ma'am.
When?
Secret. Yes.
Last year response করেছে?
No, after this July, what is the response?
3rd July, regarding the 3rd July, my lord will take some time.
That's why I'm asking. You file a report of or take instruction, and whether your authority has taken any decision with regard to the proposal given by the petitioner in terms of your.
Yes, I'm grateful. And this is my supplementary evidence because the subsequent event happens.
Correct. If your authority is ready to accept the condition.
Yes, I'm ready willing to do that.
Or further negotiation, whatever it
is. Yes.
Fortnight, my lord.
But you could, she cannot take any action against me in the meantime.
Yes.
No further,
Please see. I am not recording, but please see
no debarment or anything.
the after the counsel for the petition has filed supplementary affidavit disclosing certain certain documents which has happened after the filing of the writ application. As per the supplementary affidavit, this court find that as per the advice of the respondents, the petitioner has submitted their proposal for resuming the work, and the petitioner submitted the resume the work, but the respondent authorities are not given any response to the proposal submitted by the petitioner on 3rd of July 2023. Learned counsel for the respondents press for time to take instruction whether any decision has been taken by the respondents in terms of the proposal submitted by the petition on 3rd of July 2023. Let the matter appear on how soon? 1 week? Fortnight? Let the matter appear on 24th July 2023, 2026 under the heading urgent motion within 5 matters. In the meantime, the respondent is directed to file the report with regard to any decision taken in the proposal submitted by the petitioner on 3rd July 2023.
And it is naturally, since in open court, might observe till that they should not take an action.
Court hope and trust that till the next date of hearing, the respondent authority will not take any coercive action against.
I'm grateful, deeply. No, my lord, this is not, I'm not praising. In our young age, when I was senior, suppose I have got a brief, people just say, Chittu Mukherjee, Mohan Dottor, only said, be careful, be careful. My lord, supplementary has been handed over to them. May I leave now, my lord? May I leave, my lord?
Thank you. Yes, what is the matter?
Relate to appointment in the post of constable.
Post of?
Constable in CAPF.
So how it is before this court?
Residuary matter, CAPF.
It is not a residuary. CAPF is. Okay. Yes.
The appointment was sought for the post of constable. And the designation was cook.
You are appearing for?
My lord, for Union of India, Tapan Bhanja is appearing, my lord. For Mr. Tapan Bhanja is appearing for the Union of India, my lord. My lord, actually he's on his leg in courtroom number 10, my lord. Praying for not today.
What entry order you ask for? An entry order?
No.
What is the prayer for? What is your challenge?
My lord, the final medical report.
What is your
Because
challenge?
if your lordship kindly come to page 17 once.
17?
17. My lord, the report says.
You are Constable Cook.
Cook, yes, my lord.
Informed that have medically examined for the recruitment of Constable Cook and found unfit due to the reason mentioned in left. What is the reason?
Pitosis, that means, my lord, there is no problem on vision. But pitosis means, my lord, the drooping of upper eyelid. Drooping of it looks slightly sleepy. Just only that. Mild pitosis. Page 16, your lordship kindly come. That is the final review medical examination report. It only says mild pitosis in the middle portion, left eye, middle portion, mild pitosis, drooping of upper eyelid, nothing else. Vision is perfectly all right.
Left eye, mild
pitosis.
Pitosis.
It means I have searched drooping of sleepy looking person. Nothing else. Vision is all right. And in their manual, my lord, how to deal with such problem, there is no specific instruction.
Let the file affidavit. The petitioner has filed the present application challenging the certificate issued by the, who has issued the certificate?
My lord,
Issued by the
the
medical
review
board.
board, final
Medical board. Issued by the.
My lord, I am for the respondent, my lord.
You file the affidavit.
My lord, no need to file an affidavit, my lord. This matter can be dismissed on the first instance itself. My lord, I am begging. My lord, my humble submission is that, my lord, this petition was filed in a deleted stage, my lord. Kindly come to page 10, my lord, and thereafter page 16, my lord. See the dates, my lord.
Page 10.
Page 10 is his affidavit, my lord. And thereafter come to, my lord, page 16, my lord.
Page 16.
Yes, my lord. The review medical examination was conducted on 28th November, my lord, 2023.
Correct.
And this matter was filed on 18th December 2025, my lord. In the meantime, everything has been concluded, nothing left, my lord. I have been, my lord, I can rely upon several judgments of this coordinate court also, my lord, where filing of writ petition and ability statement, it's liable to be dismissed in my lord.
What is the time limit for filing the writ petition?
There is no time limit, my lord. But the fact
If
is,
you challenge your medical certificate
Yes, my lord.
2023 and he filed the writ application in 2025.
Yes, my lord, even then also, my lord, if your lordship condones the delay, my lord, even then also, my lord,
Condone the delay. I am asking you, what is the time limit for filing the writ application?
there is no time limit as far as filing the writ
Why you are
petition.
telling? Why you are telling?
Because, my lord, it is a belated stage I am taking, my lord.
Belated is what is the belated? If there is a time limit.
Because, my lord, the entire process has been completed, the seats have been filled up, and now he comes after, says, 2 years, my lord. Nothing remains, my lord. First thing, my lord. And second thing, my lord, he has, my lord, he was rejected on the ground of mild ptosis.
Correct.
My lord, now, kindly come to page 14, my lord.
Yes.
There also, my lord, it's mild ptosis, my lord. The very second, it is there, my lord, and it is a ground for rejection, my lord.
Correct.
Anyway, my lord, your lordship, whatsoever pleases to pass an order, I cannot say anything about that.
That's correct. But ptosis, whether the ptosis
Yes, my lord,
coming,
ptosis of the, yes, my lord.
whether the ptosis coming under the purview of
general guidelines, my lord, medical guidelines.
declaring the persons unfit for the service as a constable. Where is the very show
My lord,
that
we have been given a report also, my lord. Report to down now.
show
The key মামলা করব report থাকবে না মামলা করব my lord, a report was also given, my lord, in the medical guidelines, my lord. It is very clearly.
That's why the court want. That's why you ask to file the report, file affidavit disclosing here. This is coming under this.
Much obliged, my lord.
क्या बोला? File the application challenging the.
Oh yes, my lord, my lord, my lord. I have, my lord. I have, my lord, my lord, my lord, my lord, my lord, my lord. I have, my lord. This is it, my lord. Actually, I was running, my lord, from one court. This is the part of medical guidelines, my lord. This is the report, my lord. Ptosis. I do not know how to pronounce that word. So, my lord, it is there. ঠিক আছে দাও দিয়ে দিচ্ছি ওই জাজমেন্ট আছে
30128.
Okay, you file a short affidavit.
My lord, my lord.
The filed by the regional medical,
এটা না
regional
30128
examination, regional
এটা দরকার নেই
medical
30128
examination,
ছিল দেখো
wherein
তাপস
the
প্রথা
petitioner has been declared unfit due to mild ptosis, ptosis spelling of the PTOSIS, ptosis in the left eye. The respondent directed to file affidavit of petition within 2 weeks. Within 2 weeks, reply if any thereto be filed within a week thereafter.
My lord, I got the judgment after right now. That
On that.
in subordinate courts, my lord, rejected the
The
writ.
matter on 12th of August 2025.
আমি একদিনে মামলা শেষ করে দিয়ে রাখি না আমি মামলা
Yes, next.
Much obliged.
My lord, I am for the petitioner, my lord. Here, my lord, also same department, same post, constable.
Huh?
Same, my lord, prayer, because in 2025, my candidature in the final medical test has been
30, I am for
rejected
the one in one.
on the ground that on the saluting hand, forehead,
Huh?
is the, on
Tattoo.
the right, a tattoo.
Tattoo.
mark.
Yes, tattoo is not permissible.
Yes, my lord, I am submitting. Your lordship kindly sees that on judgment, it has been delivered by the Chhattisgarh High Court. Your lordship, similar problem took place.
Okay, let the file affidavit, same order. File.
Yes, it was removed.
Yes, next.
Deeply of
31. 81. Oh, 31, yes. Well, it is a 2024 writ petition. Well, in the meantime, the petitioner has died. And a substitution application has been taken. One petitioner substituted by 10 persons, wife and 9 sons and daughters. Well,
where is your application?
Application for substitution, that is one, can one. Can one. Names are there, beloved. We are praying that substitution be allowed and the matter may be disposed of by, if my learned friend appears, beloved, whoever is there. কপি দেয় নাইনি আমরা ডিপার্টমেন্ট থেকে কপি সার্ভিস করেছি তো আমরাই তো রিসিভ তাই তো নতুন একদম দুটো করে কপি দিয়েছি only prayer mala very innocuous prayer. There was an order of this court directing the authority at page 25 to dispose of the dispute raised before the district magistrate under West Bengal Religious Building and Places Act 1985. That has not been disposed of as yet, manner. Only he is to take a steps manner to communicate me that
already there is an order. Why you not file the contempt application?
Could not be filed, but
there is a direction.
He wants the order, communication of the order. Only dispose it of, my lord. I am giving a copy to my learned friend.
Where is your can?
Can is there? One.
Give copy. Give
application for substitution.
Within time.
Within time.
When died?
Died in February. Application in March 25.
I am disposing of this application. The petitioner has filed the application being can 1 of 2025. Pray for substitution, for recording the death of the petitioner and substitution the legal heirs of the petitioner. Now, counsel appearing for the petitioner submit that the petitioner died on 13th of February 2025, leaving behind 10 legal heirs. 10 legal heirs, as mentioned in paragraph 4 of the present application. Consider the submission made by the counsel for the petition. This court finds that the petitioner has filed the present application within the period of limitation. Accordingly, can 1 of 2025 is disposed of. The name of the petitioner is deleted and the name of the applicants. Name of the applicants have been added as substituted petitioners
Dispose
The
of করে দিন
petitioner
বলুন
is
তো।
directed to
আমরা রেখে দাও।
file the amended plaint, amended writ petition after serving the copy to the learned counsel for the petitioner and respondent. So the copy, amended copy. How it can be
Amendment
disposed of
unless
today?
allowed, my lord,
How it can be disposed of today?
take it up on Tuesday.
Within a week. Let
Well, amendment, my lord, it's to be done by the department, my lord. Lordship may pass an order, they will only amend it.
No, it is a writ petition. You have to serve the copy. It is not the civil suit.
It is not the original site.
Let the matter appear on. आज कितना तारीख है? 9-10 तारीख ना. Let the matter appear on 22nd July.
27, my Wakladnama be accepted, my lord. Department cannot accept.
No, you file in the department.
My lord, unless the file goes to the department.
Yes, it will go. It will go.
It will not go, my lord. If it goes, my lord, matter will not be listed. Or should let the Wakladnama file be recorded, kept on record.
Yes. Next. Disposed of. Okay.
22 তারিখ আবার হবে।
Next.
একটা amended writ petition করে দিদিকে আর একটা দিতে পারছে।
Lord, I beg to appear on behalf of the respondent numbers 1, 2, and 3, Lord.
Yes.
Lordship, I am for the petitioner, praying for Lordship not today.
Yes. What is the matter?
Lord, this is
Not today. My lord, in the case 32, I pray for not today. I pray for not today. As
Not today means September. Here, not today, September. Not day after tomorrow, after puja, then day after tomorrow, then December.
But here, in fact, tender matter where purchase order has been issued in May, agreement 1st June, the successful bidder has started working.
You prefer, or October you prefer, or December you prefer? I will give the date. No problem at all.
my lord, this much I am not instructed by my senior.
Not instructed, I am dismissing them. Because you persons are morning hours, so creating the problem for listing the matter. When the matter is listed, then not today. Tomorrow, where I will fit your matter? Yes, Mr. Sen, what is the matter?
Lord, this is a tender matter, Lord. I am for DVC, the tendering authority. Here, Lord, the financial bids, Lord, were opened in the month of December 2025. Then, Lord, purchase order has been issued on 8th of May. Agreement entered into with the successive bid on 1st of June. And, Lord, the mobilization has taken place on 3rd of June. Successful bidders progressing with the work. Today, Lord, at this late stage, nothing remains really, Lord.
Remains. Work order issue, work commenced. What further remains?
My lord,
What further remains?
my lord, as per my lord, at the tender note, tender has been issued. Me and the respondent number 4 was both we both was eligible for the having the tender. But
now the work order has been issued. The bidder, the successful bidder has started to commence the work. What further? Nothing.
my lord,
What remains?
my lord, if I am eligible for that position, and there is a specific, there was a specific thing. What
What is the prayer? And how your writ petition is admitted? Has been accepted by the office. Kindly come to the prayer. What is the?
My lord, I'm not having the brief even. That's why I was praying for an.
There is no gap between one line. And what is the format? It is not in form 12.
Lord, that's why I am asking for an adjournment, ma'am, lord.
Learned counsel for the petition, praise for time, full stop. Mr. Samrat Sen, learned senior advocate, appearing for the respondent authority, submit that the successful bidder has been given the work order and he has also commenced the work and nothing remains in the present writ application. Learned counsel for the petition, praise for time, according case adjourned, let the matter appear in the combined monthly list of August 2026.
Grateful, lordship.
And one I thought, two kiya છે.
33, I'm appealing for the petitioner, my lord.
No,
affidavit of service.
Key dispose.
My lord, my affidavit of service. My lord, my grievance in this receipt petition is that, my lord, my bank
Lord,
account.
I am for bank.
Yes.
Lord, I am for SGF.
My bank account has been freezed. When I have gone to them asking for the reason, they have not answered anything, my lord. What cyber fraud has been, on basis of what complaint they have freezed the account. There's been no answer, my lord.
Yes, madam. Why? Bank account is freezer.
My lord, my lord, may I have your lordship's leave, my lord? My lord, I can come back with a report, my lord, because what I have been instructed by the bank authorities that there was a complaint, MHA complaint issued by the Haryana police, my lord. My lord, that needs to be in a detailed report. I can apprise your lordship, my lord. A short time may be given, my lord. I will come back with the report.
Has filed the present application being agreed with the act of the bank authority for freezing the account of the petitioner without any reason. Learned counsel for the respondent bank is directed to file report under what circumstances, the bank has freezed the account of the petitioner, and if any complaint is received, whether the complaint consists of any order from the court, and what is the disputed amount, and what amount is lying in the account of the petitioner. Let the report be filed within a week after serving the copy to the learned counsel for the petitioner. The petitioner is liberty to file exception to the report within a week thereafter, and is the matter on 28th July.
Good.
Grateful, man.
Take a copy of.
I will serve them. Earlier state I have served, I will serve.
May I please, Your Lordship? Well, this is a similar matter. Herein the petitioner had been trading in cryptocurrency through a platform, namely Binance. Now, my lord, Binance is a bona fide trading platform which is acting under the aegis of the Financial Intelligence Unit under the Department of Finance, Government of India. The problem is that, my lord, the petitioner did trading on Binance, many tradings he has done. Suddenly, the petitioner get to learn that his bank account held with Tehotto branch of SBI was affected by a lien of 2,90,000 rupees. Now, for what? Now the bank account has been completely frozen. The petitioner wrote to the bank. No reply came from their part.
Who is to which bank?
SBI, my lord. They have
Have
been
you
duly
served?
served. I have served, my lord. I do not have the individual service today, my lord.
Then, without affidavit, how it can be taken? None appears on behalf of the respondent. The petitioner, no affidavit of service filed. The petitioner is directed to serve the copy of the writ application along with documents to the respondents and to file the affidavit of service on next date fixed. List the matter on 30th July.
My lord.
30. Next.
Man, I have stopped, but type it respondent, man. This is the affidavit service, man. Let me submit. My private respondent, man, I sent copy of the writ petition as per
Entitled to
caveat
approach
lost
the
by the
also for obtaining service of authorized. Yes.
Private respondent.
Private respondent. Who is the private respondent? Fertility clinic. What is the civil suit?
man, what happened, man? May I submit, man, one thing, man? I am tenant.
No, you submit many things. One thing is
I am tenant. I have been evicted without due process of law. By the private respondent 6 and 7 landlords.
Private respondent 6 and 7.
7. Without
There is
due
no
process
private
of law. Man, I have annexed.
There is no private respondent.
Yes, man.
Where is the private respondent?
Private respondent. I have sent the copy as per.
Sir, in your writ petition, where is the private respondent?
Yes, private.
No private respondent.
6 and 7, man.
No, only 5. 1, 2, 3, 4, 5. Only 1, 2, 3, 4. There is no 5, 6, 7.
5, 5,
Which
7,
writ
7.
petition? What is the number?
5, 5, 7, 7. 5577.
5577, good number. Good number, but there is no respondent of 67.
Page 2.
Yes, page 2.
Page 2,
Last respondent is the respondent number 4, Mukherjee fatality.
No, onno brief.
See, onno brief nahi, oi to brief hai.
5577. 26. It's 25. My lord, year is wrong. My case is 5577 in the year 2026, and it is 25, my lord. That's why it's not telling me that. Yes.
কি হবে?
First title.
वापस करो उसको, वापस करो. Who is appearing in this matter? कहाँ का है? Disposal हो गया. So these are 5. You are appearing with them. This is not a 6.
No, this is one.
None of
wrong. This is my case.
5 एखन यही तो ऑर्डर हो गए. 6 से ऑर्डर हो गए. Just इसमें क्या बोलते हैं? None appears on behalf of the petitioner. No accommodation is sought for. Accordingly, WPA 5577 of 2025 within bracket TU Das Sarkar and another versus Union of India another to dismiss for default. Yes, next.
Then my case.
अच्छा ये तो 26 लिस्ट में है.
Yes.
नहीं लो है.
रिकॉर्ड
करो.
My case.
दो listed matter is WPA. अच्छा वो तो होएगा नहीं ना. एक काम करो उसको वाला लिस्ट में कर लिया. इसको हटाओ.
Let it be
tomorrow. Come tomorrow.
Monday. And not to the
yes, next.
File दे दियो. हाँ.
That is his lordship, Mr. Brotin Kumar is appearing for the petitioner. Mr. Brotin Kumar is appearing for the petitioner, lordship. He has not come to court, lordship, due to personal difficulties, lordship.
It's an outright dismissal.
Lordship, kindly take up this matter, lordship, on Tuesday, lordship.
Legal, remember judicial department. What? Dispensing with quash and set aside the order dated. Where is the order?
Page number 55, lordship.
If lordship, my junior will. Because I'm paying time, lordship. I'll kindly take up this matter on Tuesday, lordship.
This particular order was assigned by way of a criminal revisional application. The Honorable Coordinate Bench passed an order on merit that there is no plea permit with regard to the order. The learned public prosecutor who has been sought to be retained, the learned APP, he has since been transferred to Kuch Bihar. Now, this is not where they stop. Thereafter, they approach my lord bench regarding subsequent appointment. This was not disclosed in the petition. My lord was pleased to, my lord, not to interpret. Same matter. In connection with the same real case, I have checked a person.
Yes.
Lordship, my junior will assist your lordship.
That application was prepared when the no PP was appointed after the removal of the Mr. Apurva Das as a special PP on that 3 cases. Lordship, that cause of action is another, lordship, and this application is prepared for the removal of the special PP, page number 55 you can find, lordship.
the special people Apurvo Das Lordship. Thereafter, we prefer an revisional application on the revisional application was dismissed. Thereafter, we prefer a special leave application before the Honorable Supreme Court. The Honorable Supreme Court give us liberty to
Page 63 is the order passed by the Honorable Supreme Court.
Page
The
63,
Honorable
Lordship.
Court, para 3, they were not inclined to interfere with the impugned order passed by the Honorable High Court. However, liberty was granted to avail any other remedy. So thereafter, my lord, the second application, the order of whereof my lord I have handed over to your lordship. The subsequent appointment also, they failed. Now they have come up with this particular writ application.
Yes. You order dated 10/12/2025. You have this order. The same petitioner.
Lordship.
Then
Lordship, the difficulty.
And this is of December 2025.
Lordship, the difficulty
They have not even disclosed it. This is dated 30th of June 2026. The service was effected upon us. Filed also, but subsequent to December
Lordship,
2025.
that application filed when there is no APP was appointed, Lordship.
Appointed on the 9th of March
On
2026.
that time, there is no appointment of the PP, Lordship. That's why we pray for the appointment of the PP to proceed the cases, Lordship. But this application for the appointment of the special PP who was appointed before, Lordship.
That's correct. That's correct. Kindly come to your prayer. Come to your prayer. What is your prayer? You are praying for setting aside the 2nd July. That is a page 55. Correct? 55. But this was filed when? This writ petition was filed when? March 2026. Correct. Prior to that, this petitioner filed a writ petition being WP number 2611 of 2005, 2025. In that, at the time of hearing, it was informed that the APP has been appointed conducting the case. Correct, page para 4. So you have not challenged, you have not taken the leave, then no, that appointment will be, you will challenge that appointment, you are not agreed with that appointment. Now you are challenging now before this court in the separate writ petition, how this writ petition is maintainable, and you suppress this order.
Kindly give me accommodation, Lordship.
Why accommodation? This type of
I need to take instruction, Lordship.
For your choice, the APP will not be appointed. So, for your choice, every time the APP cannot be appointed, tomorrow he will say the judge should be appointed as your choice. Can it be? File a writ petition, give the one name of the one of the person and appoint the judge.
The APP was appointed by my request. By
your requisition might be.
Initially, the APP was appointed in my request, Lordship, in page number.
What is the problem with this APP? What is the problem with the page 55? What is the problem?
No, Lordship, we are wanting to that PP to conduct all the matter, Lordship.
Correct. So the appointment has been made. So what is required? Kindly come to the page prayer B. You wanted to recall setting aside and costing. Why you want to cause this order?
Lordship, we are wanting to that the particular APP to proceed all the matter. That's why we are wanting.
Come down from Kuch Bihar and conduct this case.
Lordship, as because the matters are pending so long, Lordship, after his appointing, the matter is going so fastly, even though the one matter he already part has.
Who is the PP now?
PP has been reported by your lordship, your lordship's order. Lopamudra Das and Tomali Biswas. They said that they do not have a problem with Lopamudra Das, but they have some reservation with Tomali Biswas.
Yes,
my lord recorded that, and my lord did not interfere. Despite that, my lord, with the advent of technology, what happens is, my lord, technology at times is not a boon but a bane. So in one of the grounds I find at page 21, they are now, my lord, in fact, assailing indirectly my lord's order by way of filing this writ petition, because they say that Tomali Biswas's conduct has been challenged in some other writ petition.
In writ petition number 5921 of 2021, Lordship. It is already in listed, Lordship, in monthly list of Lordship.
It's a misadventure.
Yes, because Lordship, all the matters are pending so long after his appointment.
So why your challenge? Why the prayer B? Why the prayer B? Why your challenge?
Tomorrow there might be an application that in this particular case, I may be removed because the petitioner is not satisfied with my conduct.
Why?
Challenging.
Why your challenge?
It's because we are wanting him to appoint again. So Mr. Apurva Das, CPP, he was removed by the order.
So he has been given the Kalna, ACGM Kalna. Attached with the Heir Kalna from the appointment and special public in the following so and so. Please to relieve Mr. So and so, attached with so and so, and newly posted a Jem Kuch Bihar. So whether he will come from the Kuch Bihar to conduct this case, what is the speciality? Okay, I will pass an order every day. Coming, going, and residence, you will bear the cost. He will come, and I will direct the magistrate to accommodate for once in a week so that he come from Kuch Bihar to your Kalna.
Kindly give me 5 minutes to take instruction, Lordship.
What instruction?
For that, Lordship, to if he is able to bear the expenses of the transport, Lordship.
This is what happens, my lord, when someone sitting in Helsinki executes the power of attorney and trying to
Giving that.
That's where the petitioner is residing, I find.
Lordship, then pass an order to expeditious disposal of the 3 of the matters, Lordship.
The petitioner has filed the present date application challenging the order passed by the Legal Remembrance and Ex Officio Principal Secretary to the Government of West Bengal, Judicial Department, being memo number 3519/C/PE-195 capital A/2024 dated 2nd July 2024, wherein Mr. Apurva Das, Learned APP, attached to the Learned ACGM Kalna Purba Bardhaman, is posted at the court of JMFC Second Court, Kuch Bihar, as a special public prosecutor. Then counsel for the petitioner submit that the petitioner intending that Mr. Apurva Das should conduct the GR case number 426-213, GR case number 475/217 and GR case number 619 of 2012 pending before the Judicial Magistrate Second Court and Third Court, Chandan Nagar, Hooghly. Learned Advocate AAG has handed over the copy of the order passed by this court in WPA number 26110 of 2025 within bracket Suraj Sur versus State of West Bengal, and submit that the petitioner has suppressed the said order, wherein this court find that the legal remembrance, wherein this court find that Srimati Lopamudra Das Nandi was appointed as Learned APP service attached to the court of Learned Third Court Judicial Magistrate Chandan Nagar, Hooghly, and Srimati Tamali Biswas is appointed as Learned APP service within bracket service attached to the court of Learned Second Court of Judicial Magistrate Chandan Nagar, Hooghly, and taking into consideration of the appointment of the said Learned APPs, this court has not passed any further order for appointment of any other APPs. Full stop. This court find that already 2 APPs have been appointed to conduct the above mentioned cases, and as such, the request of the petitioner that the Apurva Das should be appointed for conducting the case of above mentioned GR cases cannot be acceded to, as he has already been posted at the court of JMFC 2 Coach Bihar as a special public prosecutor. Considering the above, this court find that the writ petition does not having any merit according to this.
Some cost may be awarded.
Regarding the PP Tomali
Paying for some cost.
Next time if you come, then I will see.
Regarding the Tomali Vishwas Lordship, there is a proceeding.
That I already recorded in my earlier order.
Humble request, Lordship.
Yes, call the
ask
next.
direction to expedite all of the matter, Lordship.
My lord, I am petitioning.
37.
Yes, 37.
Yes.
I'm appearing on behalf of Union of India.
What is the can?
Yes, my lord. My affidavit of service, writ petition, and can.
Yes, what is the can? Why you
Can
file the can?
my prayer is, my lord, add interim order of injunction directing to the respondent authorities to stay of the financial assistance for promotion of Guru Shishya Parampara repertory grant for the financial year 2002-6-27 by notification reference number NSD PAX 482 2002-6-27 issued on 29th May 2026 by the Register National School of Drama till the final decision of this application. And second, my lord, add interim order of injunction directing the respondent authorities to stay of the notification number I-205-2024 for opportunity to appeal against non-recommendation under Guru Shishya Parampara repertory grant scheme for grant year 2024-25 and 2025-26 regarding dated by the Ministry of Culture, Government of India till the final decision of this writ application. My lord, issue is arising out the, my lord, page 4, paragraph 2, and annexure is page 16. For that, the official website of the Ministry of Culture, Government of India, published that the file number I am the minutes. Some grant organization applies this scheme, central sector scheme. I am associate the Halishwar Martyrs organization and society under Society Act registration, and I am the guru in this organization. I am deprived by these minutes.
Yes, you are appearing for
Union of India.
who is filing other authority?
My lord, I'm appearing virtually for respondent number 2 and 3, the National School of Drama.
Yes.
My lord, I have major points for injunction. Two major points. Let's see the annexure 1, page 16.
Of can.
Can. My lord, paragraph, the last para is 3. The competent authorities, the recommendations of the two-tier eviction committee.
So, but you wanted the appointment on this?
Not appointment. It's a promotion of art and culture.
Correct.
Government of India, the assistance in the various organizations of the performance, dance, drama, music, and theater, and rare art also. Now, government competent authority, Ministry of Culture, through National School of Drama, they have a retrospective effect is a cooled off. There are no notification, but already Ministry published a notification is a 5 years. The 31st March 2006 is the government can provide the financial assistance, but without notification.
To whom it is to be provided? Financial assistance?
Financial Government of India.
To whom?
the Ministry of Culture to National School of Drama.
National School of Drama. So who are you? That's what I'm asking.
I am is a grantee organization, is a Halishwar Mati, and I am a this organization as a guru. Please see the page.
So that's why what you felt is of the public interest.
It's not this is my interest and
What
so many.
that's why I'm asking, what is your interest?
The last total 3,60,000 rupees is needs to pay the organization Halishwar Mati is a grantee organization. Is a respondent number 6.
To whom? To you? To whom it is to be paid?
Paid is a National School of Drama.
No.
Yes, petitioner. I am.
You are entitled to receive the amount.
Yes, my lord.
How? You worked as a as an artist.
Yes, I am an artist.
You worked as an artist in the National School of Drama.
No. It's a Halishwar Mati is the organization. And deprived Halishwar Mati, not only Halishwar Mati, so many organization is deprived.
Okay, you file the affidavit. Let the affidavit file.
My lord, major 3 points.
Okay, let them deal with that. Then I will hear you.
Because 14th July is the last date for application. It's
what application?
Is inviting the application page. 29, Annexure 4. Can application.
Annexure?
4. It's 29.
Inviting application under Guru Sishya Parampara.
Yes, my lord.
Looking for the year. What is the post? Press renewal and renewal with enhancement of the availing financial assistance. Yes.
And last is eligibility condition. And goods should process the fiscal expenses art from by document evidence.
Correct.
All the organizations under the first renewal category for the grant 6 shall be eligible but questions arising 2024 and 25.
So you applied for, you're not eligible to apply for.
Yes, I am applying.
Then?
But so many organizations also me, the competent, the Eviction committee, they will not expect. Please see the
So what is your grievance?
It's a stay application for 2024 and 25.
What is your grievance, sir? What your challenge?
My challenge is main writ petition.
Yes, what is the challenge?
And or in the nature of mandamus commanding.
Not impugn order which you challenge. Which order you challenge?
Set aside, cancel, reset, withdraw, or set aside the minutes of the meeting of Eviction committee under Guru Shishya Parampara.
Where is that meeting? Where is that annexer?
Yes. Minutes. Annexure 1.
Annexure 1 of?
Page number 16.
That is a can.
Application.
Can also is a yes. My lord.
Okay, you do one thing. Come tomorrow. My other.
Annexure P11.
Come tomorrow. Come tomorrow. I will keeping tomorrow. Now original side matter will be taken up. Correct?
Yeah. Sure, my lord.
Petitioner in person. Petition appear in person and argue the matter at length. Let the matter appear tomorrow. Yes.
Which
matter?
136 of Myler's monthly list.
Who is for the other side? Anybody is there?
I have served notice. I'm told my advocate on record has sent.
Though the matter is listed as
the first interim order was passed by your lordship on 24th
February. Item number 136 in today's list.
Monthly list.
But due monthly list.
Monthly.
But due to paucity of time, matter could not be taken up for hearing. According to petition, mention the matter for extension of interim order. Consider the submission made by the counsel for the petitioner. Interim order is extended till 20th August 2026 or until?
My lord, I have a request, my lord. It's a hotel, running of a hotel, but it's already a fifth time my lordship is extending. If some more time, my lord, I have to arrange for many things. Or lordship make. Well, maybe, my lord, for some
28th of August.
28th of
August.
Well, would it commence to lordship to fix the matter, my lord?
Come on that day.
Fix the matter.
Already my September diary is fixed. Come there on August you come, then I will fix. Yes, next.
My lord, may I have your lordship's leave to mention item number 104, my lord, of your lordship's list. This is that matter where my lord had released the matter on the ground that this relates to enforcement directorate matters. We have filed an application for recall of your lordship's order on the basis of a division bench order, which states that actions of enforcement directorate does not fall within the purview of police in action. And that's why this honorable court would have determination, my lord. My lord remembers.
Yes.
So, my lord, we have asked for
what you want?
recall of that order by which my lord had released the matter. That application is, we had heard, my lord had heard the.
Where is the ED?
I can give a notice, my lord, and come back, my lord. If my lord
ED is searching the person, now you search the ED.
my lord is hearing enforcement directorate matters because my lord on Monday also matter is fixed, my lord, for enforcement.
Where?
Before this honorable court, my lord.
104 है ना उसको Wednesday या Tuesday, Wednesday या Thursday 10 मिनट का अंदर कर. Yes, next.
I'll give a notice, my lord.
May I have your
Original side? Yes. Item number? Huh? 70 is for the other side. The matter is listed as item number 70, but due to paucity of time, matter could not be taken up for hearing. Counsel for the petition mentioned the matter and submitted the interim order still duty and paid for extension of interim order. Okay. Consider submission made by the counsel for the petitioner. Interim order extended till 20 August 2026 or until further order, whichever is earlier. Let the matter remain in the list. Next.
My lord, may I have your lordship's kind leave to mention a matter in the original side, my lord?
Original side?
Yes. Yeah. Actually, mention.
Yes.
My lord, may I mention that?
Let the officer take charge.
My lord, may I be pleased
Yes.
to mention a matter? My lord, I am seeking a recall of an order of your lordship whereby, my lord, my chance to participate at the stage of inspection and discovery has been foreclosed. My lord, the commercial suit is being proceeded with, and it's next fixed on hearing for on 23rd. So, my lord,
3rd of
July this year. My lord, the matter is appearing. My lord, my application is appearing as item number 194 in your lordship's today's report. My lord, I was only praying if it could be taken up. My lord, it will not take more than 5 minutes. My lord, I will be praying only that my chance.
Who is for the other side?
My lord, we've given notice, my lord. So, my lord, she's my advocate on record. My lord, we've sent a mail. We've given a notice of mentioning. My lord, only.
Oh, I don't. My diary is totally packed. I cannot.
completely appreciate, my lord.
cannot upgrade the matter.
My lord, the only difficulty is, my lord, we will not be able to.
All
get
matters are difficulties of one
my
or
lord,
other
the commercial court, my lord, will not be in a position to accommodate me also, my lord, if I seek an adjournment, my lord.
So this court will accommodate.
No, my lord, my lord. I was praying before your lordship, my lord.
Soft court.
Well, I cannot say that. My lord, senior friend is trying to help me out. But my lord, if the commercial, my lord, actually, my lord, the trial will begin. So, my lord, if trial begins, my lord, then this application, my lord, becomes infructuous.
You're not come forward for discovery and
Yes, my lord,
inspection,
my lord, I tell you, lordship, my lord, I need to demonstrate.
Okay, 104.
My lord, the previous advocate was being given.
Okay,
I'm
see the list.
grateful, your lordship.
Yes, call the list.
194.
Item number 1, petition.
Before lordship. Oh, sorry. My lord, this is my lord. I mentioned this
Yes,
matter earlier.
the senior is telling.
My lord, I know my lordship's list. Number 15 of
my lord, I appear for the
My
respondent.
lord, I am appealing for the respondent in this.
I can't say for further upgradation, but only difficulty is that this is challenging a civil reporting. And my lord, this one, whenever convenient, if lordship can take it up, my lord, that's all. Otherwise, my lord, this has been there, my lord, it has.
My lord, it's already item number 15 in today's list, my lord.
Item 15, but anytime next week, my lord, I leave it.
I don't think. August or September, if the fixed date is.
Wait, first week of August.
August.
We'll take our chance. First week of August, my lord.
10th August.
Very good.
Obliged, your lordship.
Item number?
Grateful.
15, your lordship.
15. As per the submission made by the counsel for the petition, let the matter appear on 10th August at 3:45.
Obliged, your
Great.
lordship.
My lord, fixing any time for this matter?
3:45.
Great.
Yes, call the phone.
My lord, I appear on behalf of the state, my lord.
My lord, in this matter, my lord, very short matter, my lord. The post office is by tenant, my lord. We have decided that the rent has to be enhanced, but a rent reasonable certificate needs to be issued, my lord, by the land acquisition collector, my lord. My lord, may I just hand over this? In a similar matter, this order was passed, my lord, only seeking a direction upon the land acquisition collector, my lord. If your lordship will kindly see paragraph 4 and 5, my lord. My lord, of this judgment, my lord. Similar order of similar nature, my lord.
My lord, I am for the postal department, my lord. If my lord gives me time for 2 weeks, my lord, I file a report, my lord. On that date, my lord, kindly
My lord, it is
dispose of this
admitted
matter.
by them. I'll show it, my lord, if your lordship will kindly see page 19 of the writ petition.
Yes, let them file the report. Let them come with the report.
My lord, the letter is there on record, my lord. They have nothing more to say than
I'll
this.
file a
matter.
report,
And
my lord.
Lordship
By
will
the
kindly see
concerned
page
officer.
19. They are agreeable to increase page 19, my lord.
Yes.
The undersigned is very pleased to receive your documents regarding enhancement of rent, and we are also very eager to enhance the house rent through FRAC of this department. But for the purpose, you have to supply the land cost certificate from the competent authority, that is land acquisition collector. Who is the respond number 4, my lord? Now, respond number 4 will not entertain us, my lord, because it's a government body. My lord, only a direction, my lord, from your lordships, my lord, that since post office is also willing and they are bound to do it, my lord, under the CPWD manual, my lord, a small direction, my lord, and the matter will be, my lord.
What direction?
My lord, prayer in terms of order in terms of, my lord, prayer C, my lord. Prayer is at page, my lord, 11. Prayer C and D, my lord. Land cost certificate has to be issued, my lord, and according
Who
to
is who is appearing for the land acquisition?
Lord, everyone has been served, my lord.
I'm for the state, my lord.
Please, my learned friend is there for the
What is
state.
your instruction?
I've not received instruction as such, my lord. Give us
Give
some time.
take instruction. Come on that.
I'll come. Weeks, my lord.
Learned counsel for the postal authorities press for time to file report. Learned counsel for the state press for time to take instruction. According cases adjourned, let the matter appear on 21st.
My lord, some preference, my lord, to this, my lord.
Upar kar do. Yes, next.
My lord, in the meantime, my lord, may I just add 2 more parties, my lord? Leave to add 2 parties, my lord.
The petition is given liberty to add the parties and to serve the notice.
21st. My lord, item number 2, my lord. Similar matter, my lord, if your lordship will kindly see page 119, my lord. The order which I just showed to your lordship, my lord, that is there at page 119. Direction was passed upon the competent authority to fix the fair rent. Now they
Same
pass,
order.
my lord, now they pass an order which is at page 147. If your lordship will kindly see, my lord, page 147. I give them all the documents. They do not even apply their mind. They did not even apply their mind and passed an order fixing the rent to be at rupees 30 when the market rate is 115. And I've supplied all the documents. My lord, may I just rely upon a
Come tomorrow.
Not my lord, some preference tomorrow, my lord.
Yes.
Item number 3.
My lord, tomorrow, any time may be fixed, my lord. Any.
Yes.
Grateful.
Online, he is leading me. First of all, my lord, I must say,
My lord, I beg to
there
the
is a
state, my
mistake.
lord. Copy of.
Actually, there is a mistake on the part. All the respondents are within the appellate sale jurisdiction, but it has been filed in the original sale jurisdiction. If subsequently it is found out, my lord will scold me, so I don't want to take the risk. But urgency is this, my lord. Tomorrow they are going to take possession. What happened, my lord, in this case? I am a lessee with a right to sublease with permission. What they say, permission has not been granted on the ground. The document which was shared to them, that they are saying this is a lease agreement, not a tenancy agreement. But I will squarely rely on section 107 of the TP Act. If a document is executed and it is not registered and rent is month to month, then is a tantamount to tenancy agreement. Well, kindly come to the impugned order. Kindly come to page 208.
208 is the order. I will not trouble your lordship entirely because of shortage of time.
Who has
Well,
passed the order?
My lord, the special secretary to the government ombudsman. Now kindly come to 209. Here my lord will get 639200 is the rent per month. Kindly mark that per month. 1076 TP Act. And the next line is, it is also found that the registration process was not completed after execution of the lease agreement. So admittedly there is no registration. My lord, now kindly apply, my lord, section 107.
It is found that the purported lease was charged 6,39,200 per month.
Per month. So it is not a year-to-year lease. So it is not coming under the documents of lease.
As lease rent.
And their objection is, they say that you produce the tenancy agreement, not the lease agreement. But this is the lease agreement. It cannot be a lease agreement. This is a tenancy agreement. On that ground, they have objected to.
Now, the larger issue, in addition to Mr. Basu's submission, larger issue is not to really gag the press. The petition has a well-known press media, and the whole purpose is to do that. I have also taken this point even in my show cause reply.
If the petition has not been served to
But we have paid. No, not sir. We have paid prayer for.
Let the impugned order not be affected. Let them come up with proper instruction.
So far as the ground they are taking, that it is not a, it is a lease agreement to give a tenancy agreement. My contention for all the question of law, 107 clearly says if a document is not yearly rent and not registered, it tantamount to tenancy agreement. I have a judgment also, my lord. Shortage of time, I will not travel alone. And 107 is squarely on that.
Yes. My lord, copy not served, my lord. We have no instruction at all, my lord.
Let them take instruction. Let the order not be implemented till next date.
Then it will be the interim order, my lord, without hearing the state, my lord.
But your impugn order 5 days. 5 days.
Ask my lord, how can I reply?
5 days means 5 days, 12.
Let's fix on Monday, my lord.
Let them in the meantime not take civil. Any resource, my lord,
Let it fix on Monday, my lord. Fix on Monday, my lord. Till date, my lord.
The 12 is the last date, is marginal. Lordship kindly give us time. Let them come. This is a case where they have to face very strong, strong malafide.
Subsequently, my lord got me. Then I will get trouble. So I must disclose that it is not.
It should be transferred to original stock from original side to appellate side. Mr. Basu is right.
After going through the cause title of the writ application, this could find that the matter should be filed the appellate side instead of the original side. But the petitioner has filed the present writ application in the original side. Accordingly, the writ petition, but it has to be, the number is to be changed.
Yes.
The
So
department.
that is the department will have to change it.
The department is directed to correct the case number of
No, to transfer it from original to appellate side, automatically that will follow.
Original side. Accordingly, WPO number 321 of 2026 is transferred from the original side to the appellate side. Full stop. The department is directed to assign the appellate side number. Appellate side. Full. This could find that the petitioner has filed the present application with the leave to file with the leave to
Leave to rule 26 without notice.
the leave with the leave to file the writ application without notice as there is an urgency. The petitioners challenge the order impugn order dated 7/7/2026, wherein it is mentioned that
That 210 will get the direction.
that within 5 days from the date of issuance of the notice, the petitioners have to vacate the said unit, full stop. The counsel for the petitioner has served the copy of the writ application to the learned counsel appearing for the respondents. Full stop. The counsel for the respondents prays for time to take instruction. Accordingly, taking into the urgency of the matter, the respondents are directed not to take any coercive action against the petitioner for vacating and for evicting the petitioner till the next date of hearing. This is the matter on 17. Can 17? You can take instruction.
Passed on
7.
1 month before, my lord. Thereafter, my lord, on the last time, my lord, my senior friend came before this court. I will take instruction, my lord. That is not a question, my lord. But what prevented them to move it earlier, my lord?
7. 26.
Yes.
210. 1 month you are telling? We are not on August.
No.
Let the matter appear on 17th April, 17th July, August 2026 under the appellate in the appellate side as urgent motion within 10 minutes.
Deep low blast.
The next matter I had mentioned for the urgency. Yesterday, your lordship was pleased to keep this a Wakaf board matter. I won't take more than a minute. You should kindly seize the impugned order. I'm by the clock, not more than a minute. Kindly come to page 371, volume 3. 371, volume 3 directly. I am a developer. I have constructed G+4 storage building. 50% is my share, 50% of board's share.
So what do you want?
Milord, order has been passed to hand over 50% within 7 days. 7 days ends today without hearing. Most importantly, the board, milord, after 11th of May 2026 has been dissolved. The person issuing this letter doesn't have authority. Milord, page 371, lordship has, milord. This is for the ad interim stage, and then milord, lordship will directly for it. Milord will see.
Call upon you.
You are hereby called upon for the final time to hand over peaceful and vacant possession of board's 50% share within 7 days of receipt of this letter.
Correct.
Now I give them a notice, milord, lordship can take it from me. I have asked them page 378. Excuse me, milord, the positive of time. I'm directly taking the lordship. 378, milord, my reply. No opportunity of personal hearing. They did not give me any opportunity of personal hearing before passing this order. So on merit, I have taken this point. Now, if your lordship sees, milord, this 371 has been signed by Chief Executive Officer, Akaf Board. This is the notification, milord, which reads 12th May 2026 in pursuance of Home and Hill Affairs Department. Memo number such and such, the tenure of chairman and all nominated members in the board of Akaf under the administrative control of the department minorities. Notification in terms of notification such and such stands terminated with immediate effect. So there is no board member as on date. So now, my lord, under section 14, subsection 9, state has the power to disqualify through a notification, gazette notification. And if state, my lord, reinstitutes, then there has to be a gazette notification as well. And you have to look at, my lord, just the provision 9. So if, my lord, anybody has been reinstituted from May to June, if somebody has been reinstituted from May to June, to issue me this letter, there had to be a notification.
That's the executive officer, not the.
No, he's the CEO.
Chief executive officer.
Section 14, first sentence. So, my lord, board constitutes of the chairman and the executive officer, CEO. Permission. There is no board. Even as I say, my lord,
The executive officer cannot be a member of the board, sir. He is the executive officer. Yes.
He has to be a member of the board.
No, kindly come that. Kindly come. Kindly come.
As of date, I have shown your lordship this order has been passed without giving any opportunity of being heard. What I'm requesting, sir, I have served them yesterday, your lordship, when allowed.
Who is appearing?
Affidavit of service. Service is fine. Let there be a limited stay of a week at least of this order.
The court has to go through. How soon? How this can be?
Sir, this is what I had shown. Then, if your lordship so pleases, Miller, may I come on Monday?
Come on Monday.
Let it retain its position. Only 2 more documents to show. Lordship has to travel.
Position is a difficulty.
You have to run there. My request, I'll place. Let it be.